The Land Use Board of the Township of Greenwich. Adequate notice of this meeting has been given in accordance with the Open Public Meeting Act, and that a notice was published in the Star Ledger and Express Times newspaper. Notice was posted on the Municipal Building Bulletin Board in the Township Administration Building in Greenwich Township, New Jersey, and notice was filed with the Township Clerk.
Roll call.
Paul Bean, Class 1. Joseph Ciccello, Class 2. Frank Marchetta, Class 3. Ray Buckwalter.
Excused.
Bruce Williams, Class 4.
Here.
Kathy Colling, Class 4. Don Marie Condas, Class 4. Mark Scuderi, Class 4. Gary Hill, Class 4. Joseph Fiamma, Alternate 1. Jeremy Blunt.
Excused.
Mr. Bill Cognac, Alternate 3. Ms. Pam Palissis, Alternate 4.
Okay, we'll rise to the flag salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, our first order of business is the August 8th minutes. Are there any comments, questions, concerns about the minutes? I don't see any.
Just one little typo. I mentioned it to John. There should be a word pursue in there as a first. Just a minor.
Okay, so first should be pursue.
Yeah.
And what page was that, do you know?
It was right in the beginning, and he was talking about, right before we did the actual motion,
Okay.
so we were discussing,
All right, I'll look, as long as I know it's in the beginning.
Okay, if there are none others, can I have a motion to adopt the minutes as amended then? Second, Mark Scuderi. All in favor? Opposed? None. Abstentions?
How many
One
abstentions?
abstention is,
Pam.
Pam. Okay. We've got a lot of folks in the public here tonight interested to see what we're going to talk about, what we're going to say. Let me lay out a few things first. The first order of business, the Township Committee has requested that the Land Use Board take a look at various parcels of land in what we're calling the Dow tract as part of option C, which is part of our looking at how we're going to satisfy our COA housing requirements. This portion is a meeting where the Land Use Board will be listening to testimony from our experts, primarily our planner, Beth McManus, and then we'll try to come to a recommendation as which parcel, if we can. If we can't, maybe eliminate some of the worst choices, and then make that recommendation to the Township Committee. This part will not be open to public questions or comments, okay? It'll be a discussion for us. You will, as the public, get that opportunity because ultimately the Township Committee is responsible for making that decision, and they'll have to have, a meeting then, and you'll have your opportunity to make any comments or concerns at that time. The second part of the meeting is an open public hearing where we'll be discussing the amended Fair Share Housing Plan. Again, we'll be getting testimony from our experts. The board will have their questions for the experts, and then we will open it up to the public so that they can also question the experts. They are questions about the testimony presented. They are not comments, okay? You will later have an opportunity when we finish the questions to make public comment. To make public comment, you'll have to be sworn in. Okay? So with that said, I'm going to turn it over to John first because you have some new information to discuss ahead of this.
All right, so just for the record, an email was sent to me from Eric Kassoff, Kassoff, who he's an attorney from Washington, D.C. He identified himself as one of the owners of the Dowell tract, and he stated in the email to me, this was an email sent on September 10, 2018, which I opened today, September 12, and it states, quote, "We were recently informed of the town's proposal to zone our site under the so-called option C," end quote. Now, parenthetically, I actually communicated option C to Mr. Tipton, who's sitting in the back with his, Brian and Seth Tipton, who are sitting in the back. They represent the developers of the warehouse option. I communicated option C to Mr. Tipton on August 24th, 2018, and I believe at some dates before that, but at least at August 24th, 2018. And then I actually spoke to one of the developers' representatives, who I thought I saw. Is Mr. Preston here tonight or not? Yeah, I spoke with Mr. Preston over the phone about it, I believe on August 28th, at which time Mr. Preston had told me that they didn't object or consent to the proposal and would see what would happen. Because that's the end of the paren. So in Mr. Kassoff's email, he then says, "Please be advised that we oppose this proposal," and this is presumably Dowell, not Mr. Preston, because Mr. Preston was on behalf of the developer. This is Dowell, one of the property owners. "Please be advised that we oppose this proposal and it cannot be considered as a viable option for the township in its effort to satisfy its affordable housing requirements," end quote. And then the email continues with the following two sentences, quote, "The township has an opportunity to satisfy these requirements at this time by working with the developers now seeking industrial zoning in a way that is fair to all of the town's citizens. Period. We urge you to find a fair and practical solution rather than suggesting options which will never be considered by the court as viable," end quote. Now, I took the email and I forwarded it to Adam Gordon, who's one of the attorneys at Fair Share Housing Center, and I inquired of Mr. Gordon whether Dowell's now objection to option C, rather than the prior, "We're not going to object, but we're not going to consent," would change Fair Share's opinion that option C provided a realistic opportunity to create the affordable housing. Mr. Gordon advised me today that the email would change Fair Share's opinion. So at that point in time, earlier this afternoon, I had formed an opinion that there was no longer an option C. However, later this afternoon, Mr. Tipton emailed me a letter dated September 12, 2018. He emailed it at about 3:15. That letter attaches a proposal for option B and some information that the negotiating committee had requested, and it includes as an Exhibit D the Kassoff email that I just referenced. I forwarded this to Mr. Gordon with the request that Fair Share reconsider its position in light of the apparent reasons for the Kassoff email, which, as in my opinion, is nothing more than a negotiating ploy. I haven't heard back from Fair Share. Adam said that he needs a couple days to discuss with other attorneys down there because he had never seen something like this happen before. The second to last paragraph in Mr. Tipton's September 12 letter states that, lastly, we reviewed your option C plan and strongly feel that it is not a viable plan. We find the plan particularly problematic in light of the fact that the Dowell property owner has already advised the township that it will not develop its land in accordance with option C. And that's what Mr. Kassoff emailed me on September 10th. And then Mr. Tipton adds, and it will oppose any effort by the township to pursue such option. So that was implicit in the email, but that's explicit in the letter. And then he says, see September 10 email from Eric Kassoff that Jonathan Drill attached as Exhibit D. So until and unless Fair Share gets back to me with respect to whether or not they agree with their change in position that option C is not realistic, or that in light of the obvious reason that the email was sent for negotiating purposes, they believe it's still reasonable, in my opinion, the board should go ahead with both things on the agenda and assume that there's still a viable option C, even though had I not received this letter this afternoon, I would have been telling you that, in my opinion, option C was no longer viable. But I don't think it's dead yet in light of this letter, and we'll see what Fair Share has to say about it. So you want to go to your agenda item?
All right. So, first item on the agenda, new business, is discussion and recommendation to the Township Committee for the various sites for option C. And I've asked Beth, you should have all received the memo with the 6 different options in there. I'm going to assume that you've all read it, but I've asked Beth to
Do any board members not have a printed copy of Beth's memo, which, by the way, anything we're saying in public, none of the stuff was, none of the email and neither the Florio Pucci letter was marked, confidential for negotiating purposes and everything, so I believe the township will try to make that available to anyone who wants to see copies tomorrow. Beth's memo to me was marked confidential and privileged, but it's not attorney-client privilege, especially we're discussing it in a public meeting. We'll make this available also tomorrow. Anyone on the board not have a paper copy with them?
So I've asked Beth, because I knew we'd have a lot of people here, to basically present the information in her memo so that everybody could see it. Well, obviously you have to darken the room a bit to do that, and so after she's had an opportunity to go show the various parcels, the various options that are being considered, and talked a little bit about the pluses and minuses of each, then we'll put the lights back on and get into discussions, and, questions about it, okay? So I think some of us are going to...
You guys should, make some room.
It's right here. No, you can sit right there if you want. It's one himself around. Just make sure you don't fall off.
I'm going to bring it down, because I probably wouldn't.
Right.
One let them know that
Oh, and
The entire meeting.
this meeting is being videotaped. This is the first of the planning board meetings. I guess it'll be a thing going on, so eventually you'll be able to see it online.
Do you need help? Do you need help?
Mike, let's go help.
Oh, ask him.
Mike, the mic, just move the mic. No, the mic, move the mic. Ask it. Move it.
Mike, move the mic. How many mics?
There you go, we're good.
So we need to bring down the lights then, or?
Can you-
Just the front ones? I think you've got most of it.
Okay. So what we're talking, have a great place to stand on, not in somebody's flag. So what we're talking about is, this is the Dow property identified in red on the map. And so the question is, what portion of the property should be subject to new zoning that would permit inclusionary housing? So we're looking at a 50-acre portion for reasons that'll be good preview for now, but that will become more clear as we get into the housing plan. And that is the 50-acre portion is zoned at a density of 6 units an acre, which is the minimum density permitted for inclusionary housing in affordable housing rules. That 6 units an acre dictates a need for 50 acres in order to yield the 60 affordable units that the township needs. And importantly, the 60 affordable units has been asked, that the township committee has asked the land use board to investigate for the Dow property to determine the correct area. So all of the options that you're going to see in the following images depict 50-acre portions of this property that could be utilized. I will also say that the various 6 options that I'm going to run through this evening came at the request or the direction of the Township Committee. Additionally, for the record, I'd also like to say that the Dow site is composed of Block 36, lots 2 and 3, with the majority of the frontage for the property along Route 173 to the south there, and a substantial portion along Route Interstate 78 to the north, and then along the eastern, or really it's more closer to a southern property line, is Beatty's Road. And you can see the residential neighborhood that abuts the opposite side of Beatty's Road as this Dow property. So with that, let's jump into option 1. So option 1, as you can see, is a long, narrow, 50-acre swath that stretches from Route 173 to Interstate 78 and includes all of the frontage along the Dow site, along Beatty's Road. So the advantages to this property is that it creates a very logical development tract for use by not only the residential developer, but also any developer for the remainder of the Dow tract. It does not create awkward lot lines that would create potentially the need for difficult buffering standards to be adhered to. Instead, it creates regular, generally straight lot lines that would be easy to work with. Some of the other issues that I think percolate when you look at the site configuration is that it provides all the residential zoning closest to the existing residences on Beatty's Road. And so what we would result with are like uses across the street along Beatty's, in the sense that we have the existing single-family residences along Beatty's, and we would have the inclusionary housing likely to include townhouses and multifamily on the opposite side. So we've got 2 residential uses. And so as a result of that, we can use the residential uses that would be developed through this inclusionary zoning ordinance to create a buffer, not a landscape buffer, but a buffer or distance from the eventual development of the Dow tract, which may include light industrial uses. Okay, so with that, I'm going to move on to option 2. So option 2 is similar in the sense that it concentrates this potential area for residential for inclusionary use in an area that's closest to the existing Beatty's Road neighborhood. The difference, of course, is that this option does not extend all the way down to Route 173, and so as a result, you have a much deeper residential area, much deeper area reserved for residential use. Additionally, because of this deeper configuration, we also have additional frontage along Route 78. And so that would mean additional buffering that's necessary, potentially additional noise impacts that would be imposed upon the new residents of this area. It also continues to provide those like uses on either side of Beatty's Road. But another difference with this is, a result of it not extending down to Route 173, you create the option or the potential for these non-residential or light industrial uses to be located adjacent to the park, which you can see down at the southern or southwestern corner of the property, where you can see those 2 baseball fields. This too, I also find, even though it doesn't include just simply one long, narrow swath of land, I think that the lot lines here, we've been able to create a right angle towards the center of the Dow tract. I'm also satisfied that this creates a regular lot configuration that would be easy for not only the residential developer, but also the non-residential developers to work with. So option 3, as you can see, really takes the western or the northern end of the Dow tract and reserves that for residential use. So it's got frontage along 173 and Interstate 78, but as you can see, it does not include any frontage along Beatty's Road. And so the advantage of this is that it would, for those who see this as an advantage, it would not have the townhouse, the multifamily uses adjacent to single-family residential uses along Beatty's Road. However, what that means is the remainder of the Dow tract is currently zoned and may be zoned for either office uses or light industrial uses. And so the natural result of this configuration is that those non-residential uses are going to be located across Beatty's from that existing neighborhood. And I think that's something to consider. So while the residential impact is going to be reduced, the impact from non-residential uses is going to be increased as a result. Also, I should note, this configuration is going to create the need for buffering from not only Route 173 and Route 178, like you've seen at all times, and not only the one property line that is going to be adjacent to a non-residential use, but now we have an additional property line adjacent to a non-residential use. And so this site requires buffering buffering against incompatible uses, either the highway or non-residential uses on all, generally, 4 sides. This next option creates sort of what I would term a flag lot, essentially, for the inclusionary housing. Flag meaning that the flag pole, so to speak, extends from 173 to the larger contiguous development tract that extends largely along Route 78. And so this has the same advantages about the use of residential versus non-residential across the way from Beatty's as option 3 before. This does also have those same issues dealing with requiring buffers along all property lines for the incompatible uses composed of either the highway uses or the non-residential that are likely to be developed on the rest of the Dowell tract as well as the Borden tract to the northwest. This obviously takes the frontage of Route 173 and makes the maximum use of it, so as to cluster the residential uses closest, the inclusionary uses closest to Route 173. And so there would be a portion of the neighborhood along Beatty's that would have opposite it a residential use, but the vast majority is going to have that non-residential use right there. The other thing to consider about this configuration, and actually, as well as this configuration and that configuration, is that what this would create is, with the non-residential uses facing Beatty's Road, that also means that their traffic, potentially truck traffic, is going to have to use Beatty's Road for access. And so what we've done for the Dowell tract here is basically eliminated direct access to that portion of the lot from Route 173 and 78 original situations. And so as a result, in order to access the Dowell property, access would have to come through Beatty's Road. And I think that's something to consider because that's going to impact, much like a lot of the issues that we raised, that certainly has an impact on the quality of life of that existing neighborhood. And then last, but certainly not least, is option number 6. And so this takes generally the middle of the Dowell tract, extending from 173 to 178, but without that frontage along Beatty's Road, and identifies that for residential use. And that has all of the, many of the same advantages and disadvantages that I've talked about for each of the preceding options, meaning the lack of residential use across the existing neighborhood to Beatty's Road, truck traffic or general vehicle traffic on Beatty's Road from the eventual non-residential development on the Dowell property, and also the buffering on all 4 sides to mitigate those incompatible uses, which include Route 178 or Interstate 78, plus the non-residential uses to be developed along the Dowell property. So with that, I think that's a quick overview of each of the options and the pros and the cons for each. And we'll have to answer any questions.
We get the lights back on. And this is back there.
Yes. Turn it off and leave it there for the hearing.
Good.
Okay, let's start off with any questions we've got for Beth. Yes, Gary.
It may sound silly to point out, but looking at some of the layouts of these lots, basically, 3, 4, and 6, how are they even considered? I mean, they just seem so crazy, I'm sorry, but why, why would that be a consideration? Is there something to do with the track itself that it can be broken up a certain way or only a certain way?
I think, I can't speak for the township committee and what led them to suggest these 3 options to be considered, but it may have had to do with creating distance between the multifamily, the townhouse use of the inclusionary district from the single-family residential neighborhood along Beatty's. That's certainly possible. But beyond that, I'm not entirely sure. It would also, of course, keep residential traffic off of Beatty's Road.
They've all got pluses and minuses.
Yeah.
Anybody else?
We just had questions, or we had comments?
Questions or comments? That's all. No, not from the audience, just the board.
No, for me, not much. So the most reasonable ones, in my opinion, is either 1 or 2, when they both have pros and cons from, I think, from a residential standpoint. If you go with 1, you have a minimum buffer, because of the elongation of the land, but then you have your residential traffic pattern going right on 173 and 9 Beatty's. However, if you go with 2, okay, you can have some maximum buffer. Can I say in our subcommittee, we talked about the 200 feet scenic corridors, as well as 100 foot from the light industrial or the ROM. Because again, it's short and spotty, so to speak. However, your traffic patterns are going to be on Beatty's Road. So it's kind of give or take. Do you concern more with, 300 housing residential traffic pattern, or you want maximum buffers? And it all depends on the road.
Any other comments, questions from the board? I'm just trying to think, in terms of, I don't even know whether to get into this now, in terms of these being developable, ultimately you have to, you have to build the houses, they have to sell the houses, and, you have to have a developer who's going to look at it and say, can I build them, can I sell them? So are any of these plans better or worse in that regard?
In your opinion?
In your opinion?
The topics that come to mind for that question are about creating a logical development configuration for use by the residential developer. And when I think about that, option 4 sticks out as being problematic. That's the flag lot option with essentially the driveway out to Route 173. And I'm a little concerned about that being marketable from a residential developer's perspective, because what that's going to require eventually, as the residential is developed, as the rest of the site is developed with non-residential uses, it's going to require access to that residential portion of the property through essentially a non-residential development. And it's going to have less of a residential character than some developers, and really what it comes down to, than some homeowners or renters may want. Beyond that, I think all of the properties, all of the options aside from option 4 create a regular development pattern, a regular development configuration that a developer could work with. But honestly, the clear configurations that are most straightforward and most logical really are options 1 and option 2, and also option 6, because that, even though that had no frontage on Beatty's Road, it does create essentially a long rectangle for development.
Okay.
May I ask about option 6? Does that still allow industrial or office type of complexes to be put on Beatty's Road?
Absolutely.
So that would create another problem, possibly for the tenant, for the folks that own the homes across the street.
Yeah, absolutely. I think one of the things that this board should consider in its recommendation is not only the development configuration, but also the impact that the location of this inclusionary zoning is going to have on that existing neighborhood. And the flip side is not only what the impact of the inclusionary zoning might have, but what the impact of the resulting non-residential uses may be, and whether the board thinks it's more appropriate to have these like uses of residential, single-family residential that exists across the street from townhouse and multifamily, or whether it would rather see non-residential uses, potentially light industrial uses, across Beatty's to that existing single-family.
I think it was important that you said you can't compare this to what it is now, just cornfields. You have to compare it to, light residential, ROM, et cetera. And
Yeah.
the options.
Yeah, and let me just put a little bit finer point. It is very easy for folks to look at development options and compare in their head to what's existing versus what's proposed. And it's not an accurate or really a helpful way to think about this, because what we should be considering instead is the proposed or potential inclusionary zoning versus the likely development of the existing Dow property under the existing zoning, which is RO, permits a variety of office uses, or potentially for a change in zoning that might include light industrial uses. Those are the two choices. It's residential and non-residential, not residential versus agricultural uses.
Yeah.
What's the status with the ball fields? I see that they're completely cut off in option one. Are they leased to the town, or what's the status with them?
Yeah, I believe that's a long-term lease to the municipality. Isn't that correct?
Listen, for purposes of this discussion, I think it's irrelevant, because access to them is not cut off under any of the options. Access is maintained.
Yeah, I don't know that you mentioned it, but you did, all of yours include, all the proposals include straightening out Beatty's Road coming out to 173, right?
So,
Running Beatty's Road straight out to 173.
no, the proposal, option number 1 certainly would make that recommendation. Option number 5 would make that recommendation, but all of...
Oh, I guess I'm just looking at the black line there.
Yeah, the black line is simply a property line, I think.
Yeah, right, okay.
Yeah.
Yes, sir.
Actually, it's unfortunate that we couldn't hear from the residents this time, but it would have been great for us to be able to hear what they want.
You'll have
Frank,
that opportunity.
Frank, can I just say something? The reason...
No,
No,
John,
no,
you don't
just-
have to go there, John. Just a statement.
Well, yeah, but the statement implies that somehow,
No, it doesn't imply anything. I understand why.
because the residents are going to have their opportunity before the mayor and township committee, just like this is this board's only opportunity to get their view.
I understand that, John. I know you can't do it. I'm just saying that it would be nice for the land use board members to hear it, because I think everybody here wants to try to accommodate everybody that lives there as much as possible. It would be helpful. I don't know, maybe...
I don't think it would be helpful. That's what I'm trying to explain from a policy point of view, because every resident has the right to appear before the township committee and voice their opinion on it.
Yeah, I
Okay?
understand that.
The township committee is looking to the land use board for their planning opinion, so now you're giving the residents, if they get to give their opinions to the board, then the board might be just echoing what they're going to tell the township committee anyway. The township committee, I think, is interested in the board's opinion from a purely planning point of view without having the input that they're going to
I don't want to speak for
get.
everybody else, but as a member of the land use board, I'm on the town committee, I'm going to hear it anyway. For me, as a member of the land use board, I'll be able to deal with it. I would think they might want to know. Maybe we can move the decision after the hearing. That's just a suggestion. If we can't, I did speak to one of the residents there, happens to be on the ad hoc committee. Their preference, this is just one resident, so I'm not saying that we just...
Frank, it's inappropriate then. Listen, the board has to make a decision. Bruce, as the chair, can make a decision. If the board wants to reverse him, someone can make a motion, and you can reverse his decision. My legal advice is not that the board can't hear from the public. It's that under the municipal land use law, the board is not required to. If the board wants to hear from the public, even though I might, think it's a bad policy move, the board can do that. But it's Bruce's ruling, and then if the board members disagree, they can make a motion, and a majority vote can overrule him. But you can't get around that by repeating what the resident told you they wanted to say to the board. That's not right.
So let me ask, is there someone who would like to make a motion to open up this discussion to, which would be questions from the public?
You can make comments, whatever you want to
Questions or
do.
comments
And I'm going to suggest by looking at how many people are out there, that if you did do that, you limit it to 3 minutes per person. But I'm not suggesting you do it, and you certainly, under the MLU, don't have to do it. And I think it's not a good idea to do it, but I'm just your advisor. You do what you want to do.
Is there someone who would want to make a motion to open it up to public comments and questions?
I'll take your advice, sir.
No, make the motion. If it doesn't get seconded, the motion gets denied.
Make the motion to open up the public comment.
Is there a second?
Where it was on.
There's no second, so the motion's denied.
Okay.
Anyway, so I think option one is the best option. It provides a buffer from any future industrial uses that may come down the road. So I'm thinking option one is probably the best option.
Okay. We got a lot of options to cover. Are there any more questions or comments before we get into the meat of making a decision here? All right.
And again, you're making you're making a recommendation
Yeah.
to the township committee on what they...
We are not
should
making
choose.
the final decision.
That's correct.
We are making a recommendation, and if we can't make one, we can't make one. If we can't narrow it down to one, that's okay too. So what I was going to suggest, because we have 6, is maybe we could do a straw poll and eliminate some.
That's a good idea.
Okay? So, let's just get a straw poll by raising of hands of who would be in favor of eliminating, option 6.
Well, keep your hands up so we can count. Well, that's unanimous.
That's everybody, okay.
Option 6 is
Option
out.
6 is out. Who would be in favor of, by show of hands, of eliminating option 5? 1, 2, 3, 4, 5, 6, 7, 12. The majority, not unanimous, the majority.
Now,
Out. Who would be in favor of eliminating option 4, the flag lot? That's unanimous again, so that's eliminated.
All right.
Who would be in favor of eliminating option 3? Not unanimous, but, yep, okay. So, we're down to 2. We do the same thing?
well, if you're down to 2, my suggestion is ask which one they, ask for an affirmative vote of which one they prefer.
All right. Let's see, let's see the hands of everyone who would prefer option 1 over option 2.
1, 2, 3, 4. Okay. Option 1 over option 2. Raise them high so we can count them. 1, 2, 3, 4, 5, 6, 7, 8. What's 9?
And
Once you pick, see, it is if the township committee did not want to go with option 1, would anyone vote for option 2 as a backup, or you're not interested in option 2? So ask backup.
okay, who would be in favor of option 2 as a backup?
Okay.
Okay, so that's everybody else. So,
I think that's where they can get the feedback.
yeah. All right, so then essentially what we need to do is make a motion to make a recommendation to the township committee that they consider, that the board recommends option 1, with its preference with option 2 being the backup. Is that satisfactory? So,
Does someone want to make that
somebody
motion?
want to make that motion? Jerry, second?
Yeah.
Yeah, okay. Let's do a roll call on that.
Mr. Paul Bean?
Yes.
Mr. Joseph Shallow?
Yes.
Mr. Frank Marchetta?
Yes.
Mr. Bruce Williams?
Yes?
Mr. Kathy Collins? Ms. Kathy Collins?
Yes.
Ms. Dawn Marie Condos?
Yes.
Mr. Mark Scuderi?
Yes.
Mr. Gary Hill?
Yes.
And Mr. Joseph Pan?
Yes.
That was easier than I thought. All right. The next order of business is the amended third round housing element fair share plan, public hearing.
So before Beth goes down there, Beth, can you please raise your right hand?
Oh, yeah.
This is a formal public hearing. Do you swear that the testimony that you're going to give will be the truth, the whole truth, nothing but the truth, to help you God?
Yes,
And just for the record, you're the board and the township planning expert?
yes.
Okay.
Okay.
And for the record, Mr. Marqueta and Mr. Beam will be recusing themselves from this part of the meeting. And wait, well, when she's ready, we'll test the lights again.
Yeah, let her get all set up. Beth, you want this down there with you, or leave it up here? Okay, let's restart it. Restart it.
You need light, or are you good?
No, not the last light. Sorry, folks. I can move it in 1 second.
It could have been, because I asked you, when you closed the thing to your projector, it probably shut off and told the computer. That's my guess. Yeah, yeah. Oh, look at this. Look at the blue light twinkling and highlighting. Fluorescent. Oh.
Update your background picture now, and the flowers are improving. Really? That'd be good too.
Bring up the temperature.
No, it's better cold than warm.
Says the guy with the jacket.
That's why.
Yeah, he got you there, too.
I'm not denying it.
Real second?
Yeah, we're set.
Okay. All right, so good evening, everybody. I'm gonna give a presentation on, I'm sorry, my computer's still acting up. I'm about to give a presentation on the board's draft housing element and fair share plan. Give me 1 minute. Okay, yes. So I'm going to give a presentation on the draft housing element and fair share plan. This is an amendment to the plan that was adopted by this board in April of this year, and it's doing primarily two things that have come out from the recent public discussion about affordable housing here in English. The first thing it does is it reduces the size of the Dumont Road property from the previous discussion, which was approximately 120 units, down to 61 units. The other thing it does is it creates a new area for inclusionary housing on the Dallas property. And so it talks about a 50-acre portion of the Dow property. The housing element does not identify that specific area because that's part of what the purpose of tonight's discussion that we just had was. So that specific area will be identified in the future. Notwithstanding, the housing plan does accommodate the 50 acres and anticipates the zoning that would be applied somewhere within that Dow property. And I'll go through that in some more detail. But first, before we jump into the nitty-gritty on that plan, I just want to be really clear and remind everybody about the history that Greenwich has with affordable housing. Although a lot of folks in this room, this may be new information, this may be a new topic of discussion in this community, but the township's been engaged in this for years in the past. This slide starts with the township's history in 2005 with adopting a housing plan, but it actually goes back more than a decade prior, the township's efforts to be compliant with this affordable housing regulation. The reason why it does that really quickly, just so everybody's on the same page, is adopting housing element and fair share plan that meets the affordable housing obligation gives the township immunity from builder's remedy litigation. And that builder's remedy litigation, also referred to as exclusionary zoning litigation, is most likely in the form of a developer suing a municipality and saying, you towns have not provided your affordable housing obligation, but I will help you do that. And that typically is in a residential development that is too big, too dense, too many units for what that township or city or town or borough is comfortable with. And so essentially what it does is it allows a developer to supersede a municipality's zoning to provide for that affordable housing. So if the zoning permits single-family residences, permits offices or retailers, but a developer successfully sues for builder's remedy, that developer is going to be permitted to build multifamily townhouses, too many units for what the municipality is ultimately comfortable with. So towns like Greenwich go through this process to adopt a housing element and fair share plan so that we can ensure that that doesn't happen. And so that's really the overall purpose of doing this. And so, as I said, Greenwich has been giving itself that protection for more than a decade. And this is simply a continuation of that process. So we started the most recent history with affordable housing in 2005. We followed code rules as they were laid out. Ultimately, we had to start the process again in 2015 for reasons that I'm not planning to go into this evening, but and if anybody wants to. But at the end of the day, it is a lot of litigation that went up and down New Jersey courts and ended with New Jersey Supreme Court in 2015 telling towns that they have to restart this process, identify their obligation, and adopt a housing plan. And that's still the process that we're trying to complete. So, first, let's talk about our affordable housing obligation. Greenwich's obligation, just like every other town in the state, is composed of three components. The first one is your rehabilitation obligation. As you can see here, down the bottom, it's 8 units. That rehabilitation obligation is calculated based on census and American Community Survey data. It's an estimate of the number of dilapidated units in the community that are occupied by low and moderate income households. It is not a literal count. It does not represent somebody driving through Greenwich and counting all of their homes. It's just based on these large data sets. The second component of the obligation is the prior round obligation. And this is the number of affordable housing units that must be created to satisfy the affordable housing obligation generated from 1987 to 1999. Those represent the first 2 rounds of affordable housing, but over the years they've been combined and are now collectively referred to as the prior round obligation and are represented by one number. This number was already calculated by COA. It is not subject to any change or any of the ongoing litigation in the state. So this number for Greenwich was set at 41 units. And as you'll see later in the presentation, just to give you a preview, that number's been fully satisfied. So really, what we're here to talk about this evening is the third round obligation, which, as you can see up on the screen, is 240 units. That number was derived from a methodology that was set forth, a methodology that is generally required to be followed by the courts. It was calculated by Fair Share Housing Center and subject to a negotiated agreement in terms of what that number is between Greenwich Township and Fair Share Housing Center. So that 204 units was negotiated down from, I believe, 299 units, down to this 204. So our draft housing plan identifies how we're going to satisfy all three components of this obligation. Now, what you don't see here is the rehabilitation obligation, and that's because it's satisfied in an entirely different way than the prior round and the third round. The rehabilitation obligation is going to be met through participation in the Warren County Homeowner Improvement Program. They run a program where low and moderate income, qualified income households can apply for their program for help with building system improvements. For example, new roof, new porch, new heating system, and so forth. So the township's continued participation in that program will meet that obligation. So like I said, we're really here to talk about the new construction obligation. That's the prior round and the third round. The prior round obligation is met in its entirety with an existing development shown up here as Greenwich Chase. That's a project that I think a lot of folks are familiar with here in town. It's the largest development, and it actually includes 41 existing affordable includes 70 existing affordable housing units, of which 41 will go towards the prior round. The third round obligation is going to be satisfied with a handful of programs. The first one are those remaining units from Greenwich Chase. Of course, we have these existing units, existing affordable units in the township. It makes perfect sense to utilize them first to meet a portion of your third round obligation, and so that's what we've done. We've carried over 29 units. And just so folks know, I'll show these sites in a minute, but let me walk through the math and the table. So we're going to carry over these existing units into the third round. Next, we have the Dumont Road property. It's a municipally sponsored project that folks may be familiar with. It's at the corner of Dumont and Greenwich Street. This was a property that was previously, under the April 2018 plan, considered for up to 144, a minimum of 121 units. That's since been reduced, as you can see here, down to 61 units. However, the reason why it shows the 61 to 121 is because it's contingent upon this new arrangement of utilizing a smaller number of units on the Dumont property, as well as the Dallas site that I'll talk about in a minute. It's contingent upon this plan being reviewed and approved by the court, and for an amended settlement agreement between Fair Share Housing Center that lays out all these issues being reviewed and approved by the court.
And just to clarify, it would have to be approved by Fair Share with an amended agreement prior to going to court to get an agreement. If there were no agreement by Fair Share, there'd be no going to court to get an amended agreement, because we wouldn't have an amended agreement to seek approval for. Is that correct?
Yes. So next we have the Dow property, and I'll show you on the map, but again, that's the property that we discussed with those 6 options as part of the board's earlier agenda item. And so that property is proposed not for municipally sponsored construction like the Dumont property, which I should have said municipally sponsored construction means it's 100% affordable housing. So the 61 units identified in the table here, that is all the residential housing that would be constructed on the Dumont Road property. However, the Dow site would be an inclusionary project, meaning that it's a mix of market rate and affordable units, such that 20% of the units would be affordable. So in order to generate the 60 affordable units cited in that table, that means that the project would include a total of 300 units, of which the 20% or the 60 would meet a portion of the township's affordable housing obligation. Next on the list is an existing group home. This is an existing, it's a single-family home occupied or owned and operated by the ARC of Warren County, and it's occupied by folks with developmental disabilities. And because it's a group home, which is a very specific type of affordable housing here in New Jersey, we actually generate credit by the bedroom rather than by the unit. And so in this case, this group home has 3 bedrooms. Each of those bedrooms generates 1 unit of credit for us. And so that's certainly a very good thing. And then lastly, we have identified in the plan the old Greenwich School. And as you can see on the table, we're not taking any credit for that. And that's because I'm not entirely sure that that property is going to be able to yield affordable housing units. I certainly hope it does. We've declared it an area in need of redevelopment, but we need this project to move forward in order for us to be certain about the feasibility of it being reoccupied or redeveloped with affordable housing units. It's a building that needs substantial improvements, and affordable housing can be costly, and it clearly doesn't generate a profit. So I'd like to see that project move forward before I can offer to the court, the Fair Share Housing Center, that it creates a realistic opportunity for those affordable housing units to be created. So with that, let's walk through the actual sites now that we've gone through the map. So the first is Greenwich Chase. Like I said, I think this is a project that most folks, if you're familiar with Greenwich, are familiar with. You can see it highlighted on the screen up here, and as you can see, it's a mix of single-family and also some duplex units. I believe there are 570 total units of them there, of which 70 are affordable. These are existing. Like I said, we're going to use that to satisfy our fire round, the entirety of the fire round, as well as 29 of our third round obligation. Next is the Dumont Road site. And as I said, this is at the corner of Dumont and Greenwich Street, but more specifically, it's Lot 26, Lot 2. It's about a 14-acre property that's currently municipally owned. And so the proposal for this site right now is to have 61 affordable units constructed on the property. As a municipally sponsored construction project, what that means procedurally is that the township would partner with an affordable housing developer for the construction of those units. The partnership would allow for the township to transfer the land from its ownership to the developer's ownership so that they can then proceed with development and, very importantly, seek outside funding for the construction of the affordable housing. There's a federal program referred to as low-income housing tax credit. That is the premier affordable housing subsidy program available in New Jersey, and it is how the vast majority of 100% affordable housing projects are constructed, at least those that are at least 40 years or so. And so it's the anticipation, the expectation that the selected developer for this property would go ahead, apply for, and receive the low-income housing tax credit. And I should say also that the selection of the developer is something that the township committee would do, and it's also subject to a public process in the sense that an RFP would be issued, interviews would be conducted with the developers, and the township committee would select them and then move forward with the development agreement, setting forth the roles and responsibilities for both the developer and the township. And then the developer would also proceed for site plan approval before this board, much like every other development application that comes to the township.
Yes, you said RFP. Did you mean RFP in Greenwich or RFQ?
It's likely to be an RFQ, but it could be both. I would recommend an RFQ. The difference being a request for proposal versus a request for qualifications. Essentially a difference as to what information and how much information the township asks the developer to submit. So next, let's talk about the downside. So this is a significantly larger property than what's necessary. If you remember those options that we ran through, the 6 options, where only a portion of the site was shown in red for the necessary 50 acres to achieve the 60 affordable units. So what the anticipation is, after this township after this board adopts the housing element and fair share plan, after the township committee makes a selection as to what 50-acre portion will be zoned, at that point a zoning ordinance will follow that will reflect the township committee's decision as to what portion of this Dow property will be subject to the inclusionary housing. So notwithstanding the size of the property, which is a couple hundred acres, only 50 acres of it will be subject to the rezoning for inclusionary housing. And so again, we're talking about 6 units an acre, be a mix of townhomes and multifamily units. That's 6 units an acre. I also want to be clear, is the minimum density permitted for municipalities to use to generate inclusionary housing. There must be a minimum density of 6 units an acre, and it must include multifamily and or townhouse units. You can't accomplish inclusionary housing with only single-family detached units. And so, just to be clear on the map, 50 acres, total of 300 units, of which 240 will be market rate, and 60 will be affordable, that contribute towards the township's obligation. And so lastly, we have the Old Greenwich School, which, as I said, I'm not requesting credit for it at this point, however, is identified in the housing element should it come to fruition. Identifying it now and saying we'll seek credit if and when affordable housing is created on the site eliminates the need to do another amendment in the future as this project progresses, if and when it progresses. But notwithstanding, we've included in the plan, the anticipation is that it will be used for 100% affordable housing, perhaps families, seniors, special needs. It's already been declared an area in need of redevelopment, and so the next step would need to be redevelopment plan and selection of a redeveloper that can then proceed with the redevelopment of the site and the reoccupancy of the building. So that's the entirety of the township's plan. It's slightly changed, but in a very big way from our April plan. So we've really just added one new site, but in addition to adding that new site, the Dow property, it's given us the ability to reduce the Dumont Road site by about 50%. And so as a result, we've got the prior round net, again, with 300 shapes. 300 shapes, 29 of the units is carried into the third round, and then the third round is complete with 61 units of the Dumont Road property, 60 units of the Dow site, 3 units of the Arthur Greenwich group homes, and then if Greenwich School comes to fruition, that's great, and we'll grab credit for that in the future. And so the next steps for the process is for this board.
Beth, before you go to the next step, I just want to ask you, in a number of places in the actual amended third-round housing element and fair share plan, does it state that it's expressly subject to being Fair Share Housing Center in the township entering into a further amended settlement agreement to provide for the amendment of the township's plan to allow the so-called, what everyone's referring to as option C,
Yes.
which is the Dowell site?
Yes, absolutely. Everything is predicated on that amended settlement agreement and its approval by the court.
And if Fair Share does not agree to sign the amended settlement agreement, under the terms of the amended third-round housing plan and Fair Share plan, the plan would revert to what we're referring to as option A, which is
April plan, which includes 120 units on the Dumont Road.
121.
121 units, thank you, on the Dumont Road
Right.
property.
Okay, just wanted to make sure that that was clear.
No, thank you. It's a very important point. So the next steps are adoption of the plan. Once, as adoption of the housing on the fair share plan by a land use board or a planning board, what that means is the housing plan becomes part of this township's master plan. It's just simply another element, just like your land use element, your circulation element, and so forth. But because the housing element has additional purpose, which is to generate that immunity from builder's remedy, and because it's required to be reviewed and submitted by the court, there's an additional step, and that is that the township committee must endorse the plan. And so this plan will go before the township committee for their endorsement, which is simply passing of a resolution. However, it then must be submitted to court for that settlement agreement to be amended and approved by the court, and also for the court, for the judge to review and approve this housing element and fair share plan. And that would be done via a compliant, what's referred to as a compliance hearing before the court, where this housing plan is reviewed by the court. The judge will presumably approve it, or I'll say presumably approve it. And then lastly is the implementation, of course, and that means adoption of ordinances and any other implementation actions that may be necessary. So in this case, it would include issuing an RFQ for the developer of the Dumont Road property, in addition to adopting the ordinances that are going to facilitate the development on both Dumont as well as Dow. And so with that, I'd like to open it up to any questions that the board or anybody else has.
So when's the drop dead date on this?
Yeah. No, I'm sorry.
When you say, when's the drop dead date for what?
I said you went back to your previous slide, when everything has to be adopted.
Under the judges, under the amended,
Assuming that's the drop dead date.
right, under the amended order, which Judge Miller entered on August 9, 2018, if there's going to be an amended settlement agreement, then that amended settlement agreement would be signed and then subject to an additional fairness hearing. If an amended settlement agreement is signed, and it must be signed no later than October 15th, then the township must introduce and adopt by November 15th the ordinances implementing this amended housing plan element and fair share plan. If there's not a further amendment to the underlying settlement agreement reached and executed by October 15th, then the township shall proceed with the adoption of the ordinances in conformance with the underlying settlement agreement no later than November 15th, 2018, which would be what is commonly referred to as option A, which is the 100% affordable housing project with the 121 units on Dumont Road.
Okay, so following up on that, this whole monkey wrench with option C, whether it's
Okay, again,
feasible or whatever, is there a document date for that, or we
yeah,
just,
the fair share would have to agree
in the next,
by October 15th to sign an amended settlement agreement.
whether we can or can't?
Right. And if they don't agree, whether it's because fair share, for whatever reason, or whether it's because the Dowell, sent in the email to get its leverage in the negotiations with option B, it doesn't matter what the reason is. If fair share does not enter into an amended settlement agreement by October 15th, whether it's option C or option B, which has now been
So,
submitted,
Next question,
Right.
so, option B is on the table or not on the table?
option B is now on the table because they submitted it
Okay,
today at 3:15.
and then,
But you have till October
October
15th,
15th is the date.
correct.
This is support for questions from, and comments from the board members for our professional?
Yes.
So, anybody else?
I would suggest to make it questions now, let the board members do their comments after,
Right.
because after the board asks questions, the public now has the right to ask questions, then the public has the right to make comments.
Okay.
So, the Dumont Road site, we just changed the number of units there, right? We haven't changed the dimensions of
That's correct. It is the same property with roughly half as many units.
Any other questions from board members?
Can you just lower it
You mean make it a little warmer?
Warmer?
Raise it?
No,
Can we do that?
I mean, really.
Is there a member of the township committee in the House that knows how to do that? I thought I saw Brad Perone somewhere. There he is.
It's cold. It's freezing. It's freezing. I'm not gonna say something.
It's 60 degrees up here. Okay. No, for the questions. Yeah. Correct. Yeah, okay. So, let's get a show of hands out there. How many of you have questions for our planner? And how many of you have comments?
How many have comments?
Yeah, well, comments for the
Questions for the
board.
planner, then separately comments for the board. So start again.
Okay,
Questions for the planner who's been placed under oath.
okay. And comments to the board.
Comments to the board.
Okay. So it's not too bad.
Right.
Okay. So, we're going to start with questions. Please come up to the podium, state your name and your address. And again, this is for questions, not for
Comments.
comments. Okay?
Chairman, and the board, thank you. Name is Brad Perone, 110 South Crossing. I'm also a member of the Township Committee, and I just wanted to come up here and present something that's sort of a question, but it is somewhat of
So, do we do this now, or do we have
This is
to?
a question.
This is a question. It's got to be questions. You got to follow the same rules that they do.
Consider this proposal. Thank you. So, as everyone is aware, I know Beth's already gone through this.
If you're are you gonna be stating if you're gonna be stating things, we're gonna have to get you sworn in, but again, you might wanna wait until after the questions and then make your comments.
Wait,
However you want me to do it.
Yeah.
I'd prefer if you wait until we get to the comment section.
Yeah.
I'm fine with that.
Okay. Next,
True questions.
or we'll do the same thing to you.
Good evening, Rick Ferrera, 103 Alden Road. Talked about briefly option B today. I'd like to get clarity on option B and C. If you can share that.
I haven't had enough time to look, again, I got this letter emailed to me at 3:15, and I got in my car a little after 3:30. So,
In a general sense?
in a general sense, it's a proposal which we've stated before, which is warehousing on 3 properties, not 3 lots. The Dowell property, the Voorhees property, and the Santini property for warehouses, and I don't want to say in exchange, but the benefit to the developers is obviously a rezoning from, in 2 cases, office to warehouse, in 1 case,
RCD.
I think RCD to warehouse, and the benefit to the township would be that the developers would, and again, unless something in here changes that, and I haven't read it, the last understanding of the proposal would be that they would construct at their own cost and expense the 61 units at Dumont and the 60 units at Dowell, but there'd only be 51 rental units. The other 70 would be for sale units. And the numbers on which site is not that important, because I can't remember them off the top of my head, and again, I haven't seen if that has changed, but that was the concept.
But,
So would anything be built on Dumont with option B?
Yeah. Oh, and something would be built at Dowell under option B. The biggest benefit to the township, in my opinion, is you wouldn't have market units at either. They're all going to be affordable. And the other, the other benefit was it takes away the financial risk of having a municipally sponsored 100% project.
If we know what type of warehousing units?
Well, that's what...
it's really not a real proposal right now.
No, it's a real proposal. I just haven't had the time to read it, I'm telling you.
We don't know what it
It
is.
came in at 3:15 this afternoon, so I imagine it's in here. I just haven't had the time. I had to get in my car and come out to the meeting.
Is that going to be presented to all of us at some point?
I have no idea. That's going to be up to the township.
But that's
committee.
really not the topic.
It's not the topic for tonight. It has nothing to do with the housing element and fair share plan that's being proposed. This housing element and fair share plan basically is the backup plan if the township can't reach an agreement on option B. This would put in place option C, and the beauty of it is, it only puts in place option C if fair share and the township enter into an agreement. So if they don't enter into an agreement, the board hasn't committed to do option C if option C can't be done.
It was just mentioned
Right.
option B. I just wanted to clarify.
Right. And if there's going to be an agreement on option B, it's going to require a further amendment of the housing element and fair share plan.
All right, let's get back to questions about the housing fair share plan. Yes, sir.
By the way, these are supposed to be questions of our witness on what she testified to.
Bernie Pratt, 107 Kennedy Mill Road,
Did you get his last name?
No.
Can you please spell your last name?
A-R-A-V-N-I-C-K.
Your question.
I just have some general questions. You're talking about the Dell property. Did you say the township is going to purchase 400 acres or 50 acres?
No. So the proposal for the Dower property is to simply rezone a portion of it. There's no purchase or acquisition, or in case anybody's thinking condemnation, proposed for the Dow property. It's simply a rezoning of a 50-acre portion, and then the affordable housing as well as the market rate housing would be constructed by the developer without the township's, aside from the site plan process that they'll have to go through and the need for site plan approval.
So this is really no outlay from the township?
Absolutely not. There's no,
Correct.
there's,
Is that correct?
correct. No, absolutely, there is no outlay from the township, there's no subsidy required for inclusionary zoning. The only action necessary by the township is to adopt the zoning, and then later, presuming they come in with a conforming plan, to issue site plan approval.
And those 350 acres, and they're just, the zoning is unchanged?
Right, this 50-acre portion, this zoning, could be applied regardless of that existing zoning and how it may change, or if it changes.
One other question for Crystal Ball. This is a tough one.
Mm-hmm.
Assuming everything is approved tonight,
Yep,
which is a ridiculous assumption,
sure.
but assuming everything is done tonight, when would the first shovel be turned?
Oh, gosh. You mean, so assuming everything had site plan approval tonight? For
10 years?
It's impossible to know. It's going to depend on the market, and it's going to depend on the developers that have received the site plan approval. For the Dow property, where that's market-driven, because that's inclusionary housing, it's common for developers to seek site plan approval with the anticipation that they're going to proceed with development shortly thereafter. But I can't answer your question as to when they're going to seek site plan approval, because that's the bigger issue for determining when Dow will move forward. When will a developer that wants to build a residential acquire the property? When will they decide to seek site plan approval? For the Dumont Road property, that property is going, should this be approved, a developer will be selected, they'll seek site plan approval, I would assume, in 2019. They'll apply for funding, depending on when the funding round is set, because the date hasn't been set yet. They may seek funding in 2019. If they receive it that first year, I would expect them to break ground perhaps as early as 2020. That's the earliest the Dumont Road property could be developed, and quite frankly, I think that would be pretty quick. It might be, 2021 or so.
One other valid question, will there be environmental impact studies that will be required?
Yes, just because the site is included in the Housing Element Fair Share Plan, it does not eliminate the board's ability to request studies that folks are used to seeing, like traffic, like environmental.
And then would that, say, involve, changes to Route 173?
For the Dowell site, yes, I would expect that they're going to have to analyze the traffic impact along that road.
Questions? Questions? No comments?
Did you get his name?
What's the last
You
name?
gave, nice and slow, spell it.
CHA. And as in Nancy, E as in Tom, C as in Joe, I as in India, S as in Sam. First name Constantine, C-O-N, S-T-A, and J-A.
Thank you.
Okay? And here have a few questions about the Dow property. Can its owner legally block the town going forward? Yes or no?
Can who?
Yeah, because the owner is paying for it.
Can the owner block the plan moving forward? That's your question, right?
You mean option C or the plan?
Our plan includes using our property in order to meet our obligations, yes or no?
He means option C. So you mean option C?
Yes, that's option C.
Yeah, see.
They can't block the township,
Just
but
listen to the
the bigger challenge that John had identified earlier is that we need Fair Share Housing Center to be in agreement with the township's plan. And they had indicated initially, pursuant to John's overview, that when they understood that the property owner was objecting to the zoning, they were uncomfortable with the amended settlement agreement. However, given the new information that came to light with the additional proposal that seems to have come in this afternoon, Fair Share is reconsidering that position. So it's a bit more complicated or convoluted to suggest that the property owner is blocking it. The question is more that we need Fair Share Housing Center to support the new plan that includes rezoning a portion of the Dow property.
We have a deadline that we need to submit a proposal, right? And I know here in the West, it takes forever sometimes when the courts get involved in different sites of fighting.
Mhm.
So what happens if the owner of the property gets the town to tie it up in court, and then we miss our thing?
Well, that's a little bit different. In this scenario, the property owner is going to be engaging in litigation against the township for the zoning. So the township will be able to proceed with adopting its housing element. They'll be able to proceed with going through the court process for having the housing element reviewed and approved by the court. So that litigation won't stop that process. The litigation would continue on a separate track. If the property owner was successful, yes, we would have to pivot and amend the housing plan, but we're not obligated to assume at the outset of that litigation that the property owner is going to be successful.
So do we have a plan B in case that were to occur?
Yeah,
Yes,
Plan A is,
yeah.
Plan B is option A.
Yeah, Plan B is the backup plan the backup plan is the 120 units on the Dumont Road property. 21, thank you. The 121 units on the Dumont Road property that is reflected in the township's April 2018 Housing Element and Fair Share Plan.
But I think the public told you, elected officials here, that's not acceptable.
I understand that.
Yeah, we understand that that's what the public said.
So,
The entire board understands that that's what the public said. The mayor and the township committee understands that that's what the public said. But
later, okay. One more question. How could an objective fact buyer conclude as far as what is the best option for the Dow property, absent quantitative or semi-quantitative criteria and metrics, in absent input of the most important element to this equation, which is the impacted residents immediately next to the property? That defies logic for me. Please answer.
I'm not sure, I don't understand the question.
You cannot conclude what is the best option, other than just taking a point and flipping it and say, what is the better option? 1, 2, 3, 4, 5, 6, we have 6 options. Okay? Absent quantitative or semi-quantitative criteria and metrics. I know a number of them I'm volunteer, but I can do the same thing. And then, whose opinion is better? That's why we need to have quantitative criteria and metrics and input from the public, as Mr. Frank correctly said, but nobody listens.
I think I understand what you're saying, but I think the challenge here is that the Land Use Board has been tasked with adopting the plan that includes the Dow site in some portion of the 50 acres. That 50-acre identification is going to come from the Township Committee. So the place for the quantitative measurements, I'm not sure, sits here. And also, I'm not sure I agree with the premise of the question that you need the quantitative data, presumably a survey or something along those lines from the residents in order to make a planning decision. That's not always the way proper planning decisions are made.
That's how the property assessment is being done, and that's how conclusions are being drawn that are valid. Otherwise, conclusions that are turned upside down, because somebody has to say, well, here's my evidence. Well, you know.
Okay, I think we're getting into comments.
yeah, that's a comment, it's not a question.
Okay. Next, anyone else have a question? I got 2 here. Go ahead.
Jim Mason, 14 Barnesville Court, Stewartsville. I had a couple of questions. One, the Dumont property is in the suburban planning area, and the Dowell tract is in a rural, environmentally sensitive planning area, per the documentation on the website from the town.
Mm-hmm.
Is that going to necessitate extra studies on the environment concerning the development of that track?
No, it doesn't. What you're referring to are the planning areas identified in New Jersey State Development and Redevelopment Plan. Those planning areas are a necessary component to, identifying them as a necessary component to a housing element and fair share plan, so that the township's planning can be related to state planning and so forth, but that data is not used to generate the need for additional studies. It simply has a different purpose.
Okay. Next question. I've been told by a couple of people, actually, or one specific person, that we should accept the Dowell tract development, because if we do, then there will be no more opportunity for affordable housing to be placed on the township. Is this correct?
I'm not sure I've heard...
Okay.
Who told you that, by the way?
That was told to me. Yeah, we did get that in an email.
From who?
From a committee member.
Well, is he here right now on this
No, he's
board?
not.
Okay, I'm going to take a guess that he recused himself.
Yes, he did.
That could be why he recused himself.
Well, I mean, do I get an answer to the question? By accepting?
We don't know what you're talking about, so you have to ask him.
Because he gave me the
I
question.
understand, he's not here right now, so you go ask him.
Okay. Well, I figured you were the lawyer, so I mean...
I don't know what to tell you.
Information than he would have.
I don't know what to tell you about that.
Okay. Next question. How can we approve, or, take a motion if you haven't gotten a chance to digest the new proposal that you just got?
A motion on,
How do you approve the housing plan?
how do you approve the housing plan without option B?
Yeah.
Because the housing plan is actually designed, it doesn't have option B because they didn't give us option B within the time constraints to approve it. So I said before, this housing element has been set up specifically in the event we didn't have an agreement on option B, and it's specifically subject to Fair Share agreeing to option C. So if Fair Share doesn't agree to option C, it reverts to the existing housing element, and until and unless the Township Committee gets a chance to look at option B, which wouldn't start with this board, it would start with the committee that they, the ad hoc Affordable Housing Committee that they created to look at this, which again, the proposal came in at 3:15. So that committee is going to have to get together, and it's going to have to go to the mayor and Township Committee to decide, and whether they give direction that they want the housing element and fair share plan further amended. This plan specifically was written without option B because we didn't have option B within the time constraints to get it done.
So I was,
Yeah.
I figured I would ask.
That's why. Option B came in with all the data at 3:15 this
Right. I
afternoon.
understand that.
Right.
And
And this plan, by the way, has to be on file with the planning board 10 days before the hearing.
And do the people who are proposing option B, the landowners, realize that the P-Berg is putting up a 3.5 million square foot,
Listen,
which is 6 parking?
That's beyond the scope of the housing element.
That's not a question for us.
Not a question
That's a
for us.
question for
You
them.
can ask them.
All right, thank you.
But Beth, to answer Weber's question, we are expecting additional COA requirements in the future, right?
As of right now, we have to assume there's going to be a fourth round in 2025, unless something changes at the
Right,
state level.
I understood that from the documents on the website, that the 2025 will be the next round.
Yep.
If option C is adopted and goes ahead, I'm assuming with the amount of land that's there, if they do not further develop that, then that would be available for further COA requirement, obligations?
It may be, it may be. It's hard to anticipate at this point because we're going to have a new set of, we should have a new set of rules, a new set of obligations, and so the necessity to use any undeveloped lands that's either on or surrounding the Dow property it's a little hard to anticipate at this point.
Okay, I'm just asking because again, you should be happy if they develop the Dow track, you're not going to have, any more obligations, there's going to be nowhere to put the future obligations.
Listen, I'm not Don't attribute that to me, and don't attribute that to Beth.
I'm just telling you.
Okay, you're getting into
I
comments.
understand.
You're getting
I'm
into
just telling you what I'm getting.
Well, you can say that in comments, but that guy's not here, and that's not a question.
Okay, thank you.
Thanks. Next.
My name is Doris Sullivan, and I live at 13 Barnswallow Court.
Can you spell your last name?
Yes, I will. It's spelled G as in George, U-L-L-I-O-N. And my question is actually for Beth. In her presentation, she said that the township has been working for a long time to avoid immunity from the builder's remedy.
To make sure we keep immunity from builder's remedy.
To avoid the builder's remedy.
Yeah.
All right. And the reason for that was the
Mhm.
builder's remedy, as you explained, makes too dense, too many units
Yep.
given for what the township is comfortable with.
Yes.
In the Dow proposal, is the 300 units a builder's remedy? I don't understand
Oh, and
that.
That's a great question. Yeah, let me answer that for you. So the short answer is no. But the reason why the answer is no is because the zoning on the Dow site should this plan be adopted, should the implementation proceed, comes at the direction of the township. And it comes with the township's preferences for density, for unit type, buffering, setbacks, and so forth. The township has the ability to design the zoning that housing will have to comply with. In a builder's remedy context, I would expect more density, so much higher than 6 units an acre is likely, and a developer is going to seek to maximize use of the land, and that may include reduced buffers, reduced setbacks, and so forth, so that they can create the maximum, their goal is, of course, maximum value for their property. The township's goal is to create a quality development that can be integrated into the community and can create a new place for living that has a high quality of life, just like other places in the community. So there are two different purposes and two different intents in crafting the development parameters. The township's intent is going to be much different versus a developer in the context of builder's remedy. So I would say not only do they, procedurally they're very different, but I think the results are going to be would be very different.
And it's just the number of units we've gone kind of from 121 to 360. So it's triple what we thought. Is that did I understand that correctly from the...
Yeah, generally, yeah. The April plan includes only affordable housing units, the 121 on the Dumont property, and yes, as you said, now it's 60 and 300 for a total of 360.
Thank you very much.
My name is Bill Gullion. I live at 13 Barnswallow Court.
I bet I can guess how you spell your last name.
Yes, you can. With regard to the options you outlined for ways to cut up
Mm-hmm.
the Dow property, you talked about these options from the perspective of the township. How is the Dow, the owners of that property, how are they going to perceive those options? Are they going to say, this is assuming they come to the table?
Yeah. Well, I mean, as of
Are
right...
they going to have a preference for one of those options over another?
Are they going to have a preference? I can't speak for them, but...
You worked with
Well,
developers
can I say something?
before.
They objected.
I know. Well,
So I don't think, right now, they don't have a preference. Right now, the preference is that there is no option C.
Okay, I understand.
But I
assume that they eventually come to the table.
Well, one of the considerations I advise the Land Use Board to include is creating a regular or a logical development boundary or configuration. You know, I would not advise that the township create a really irregular site boundary. I would advise that they try to keep to traditional development tracks, which are oftentimes somewhere along the lines of square or rectangular. It eliminates property lines that may need to be buffered. It eliminates awkward areas of the development that really can't be used. So from the developer's perspective, again, I can't speak for them, and as John said, they've objected, but if I were a developer, I would want to see the most regular configuration.
We're not talking about the developer, we're talking about the landowner.
Well, but the land, that may be, the landowner may be,
The property owner objected.
Okay.
The property owner objected in the email to me dated September 10th.
Okay, so probably shouldn't even bother talking about this until he comes to the table and...
Well, and by the way, just for the record, I offered the developer input into which option, when it was only two options they would want, and that's when Mr. Preston, who's sitting in back of you on the bench there, said that they weren't going to take a preference, they weren't objecting, they weren't consenting, they were going to wait and see what happened. Mr. Tipton, who's standing up behind you, he was the one who sent the letter today after Mr. Kassoff, who identified himself as one of the Dowell owners, objected to having their property in option C at all. So, in other words, ask them.
With regard to the 121 unit number we've been talking about,
in the April plan.
in the April,
Yep.
how likely, if you have to go back to the fair housing people and say, we want to do a slightly different deal than we talked about in the past, how likely is that 121 number going to stay 121?
Well, I mean, we've already discussed the parameters of the current draft housing plan with them. And so they're generally supportive of it. There's a bit of a hiccup today with the back and forth on the emails, but as of yesterday, just for clarity, this plan was generating support from Fair Share Housing Center, and they would have supported our efforts to see this approved by the court. Now, as we talked about today, there's been a little bit of a hiccup with some back and forth that needs to be straightened out.
And just for the record, because the email to me was dated September 10, but I was out of the office on September 10 and September 11, so just for the record, I didn't see that email until a little before 1 o'clock today. So when Beth says,
Yes.
up until that email, that we have a first amended settlement agreement with Fair Share. They specifically agreed to allow us to pursue both option B and any other options, including C. And the judge actually saw that. We had a case management conference. The judge entered this order I referred to before on August 9, extending our time to give us the opportunity to do it. So until that email was sent, which I saw today, and I immediately brought to Fair Share's attention, I would have stood here tonight, and Beth would have testified tonight, that Fair Share was 100% in favor of that housing element and Fair Share plan. We can't do that right now. We're not giving up on it because of the letter that they sent today. If that letter hadn't come in, we probably would have said, all is lost. But the letter came in, we sent it to them, and that's raised the question in our mind if that email was real or if it was just a negotiating tactic.
So they've essentially agreed that the change is okay with them.
Yeah, conceptually, they've agreed that the change is okay whether we go to warehouse and split up,
Their 121 houses.
as long as they get their 121 units. And what are they interested in? Whether it's realistically a realistic opportunity to get them created. If the answer is yes, they're going to agree. Why? Because they would prefer to work with the township, because they think if they work with the township instead of fighting the township, it'll make it more likely that they get built.
Any more questions? Oh,
Brian Tipton, I think you all know that by now.
Yeah. But the question's correct?
Pointed at, I've been accused of things. But I am the attorney for the Plan B option proposal. My clients are Panatoni, DPISZ Acquisitions in Germany, and Petrucci JP. So it's the three property owners, or three contract developers of Antini,
this is a question, right?
I just wanted to announce who I was.
Okay.
You asked me to,
Okay.
you asked some questions that people say who they are.
Yeah.
I can give you my home address. So, my two questions to Beth. Did the township perform any kind of fiscal impact analysis study with respect to option A?
No.
Did the township perform any fiscal or community impacts study with respect to option C?
No.
Those are my only questions. If you have a comment, that's just a deal with the option.
Right. All right, thank you. Anyone else have a question?
How you doing? Mark Monteri, 102 Batesford.
Can you spell that last name, please?
You ready? All about it.
Nice and slow.
Fornacari. So in brief, some of the questions that strike me would be, as a planner and land use board attorney, it sounds like this fair share development plan has been in the works for at least 18 years. I think, or probably more, 2005, and you said possibly a decade prior.
Well, there are different plans for addressing different rounds and different obligations. The point is the township has been engaged in the affordable housing process and being compliant for that long. Not that this particular plan has been in the works that long.
In particular, option A.
Well, option A, to answer that, that's been in the plan since 2015.
So 2015.
Mhm.
Yeah.
So with the original inception, I'm sure there was negotiations before that was actually ratified in 2015, right? With that being said, why now is option C even out there, and why was that not exposed or even identified early on when talking about options that this town has and all the residents may have in the community?
Option C, and essentially what you're asking about, I think, is use of the Dow property.
Yes.
Yeah. That came to be most recently at the direction of the Township Committee, in particular when property owners or contract purchasers for the site alerted the Township in their interest in proceeding with development on the property or discussing development on the
But
property.
that's the existing option C. The Dowell property, there's another person that I noticed in the audience, Jordan Gunther, who is the project, he's the guy with a mustache sitting in the third row, who's now smiling. So he's a representative of Dowell. In 2008, Dowell was part of a plan that would have provided for affordable housing, and
Still great.
they were close to having an agreement, but Dowell said no. So to answer your question fully, the Dowell property was on the table, almost agreed upon in 2008, taken off the table.
So at some point, it was actually identified as a viable option.
Yes.
So then we went to the table in 2010 and threw that option to the
No,
side.
they said they were not interested in doing it. They walked away.
The letter you read into the record tonight. So, but that doesn't change what option C is. Kind of my argument is, how much are we actually planning for this? Who looked at the fair share plan? I'm actually identifying that the fair share plan was not accurately looked at, and all options weren't considered.
Okay, that's for comments. That's for comments.
All right, so...
You have questions? Any more questions?
So, in question, I have a question for the land use board. When is the first time you saw all 6 options?
It's questions for the planner only.
I apologize, I had to say that. So in your, Beth, in your matrix, you had 204 units obligated. Was that prior to the agreement too? Were we always at 204?
The agreement is what set the original agreement is what set the obligation at 204 units. We had an agreement in, was it December 2017?
Correct.
Yeah, December 2017. The first settlement agreement with Fair Share Housing Center and Township of Greenwich was executed, and as part of that settlement agreement, the township negotiated its third round obligation down to 204 units.
So we went to 204, and then it was subsequently negotiated down to 121.
No. So we negotiated down to 204, and we only needed a minimum of 121 units on the Dumont Road property because we had excess credits from the Greenwich Chase project. We had the ARC of Warren County, and then we also had bonus credits. Rental units that meet a rental obligation generate an extra unit. So all of those factors combined yielded a necessary number of 121 units of new units on the Dumont Road site.
And anywhere in the 121 factor, is that based off that there are rental units versus
Yes.
selling?
Yes, it's because those are rental units that we were, able to generate rental bonus credits, but also we're able to meet the rental obligation, and if we didn't include rental units, we would not have been able to have a compliant plan, we would have not gotten approval, or we would have not gotten a settlement agreement with Fair Share Housing Center.
I'll wait for the others for comment. So I have nothing more.
Any more questions? Okay, so we'll close that, we'll go to comments. For comments, same drill, come up, state your name and address, and you'll have to be sworn in. I'm gonna give the committee the first, Brad.
So again, can you identify yourself for the record?
For the record, Brad Perone, 110 Canal Crossing, P-E-R-R-O-N.
Can you raise your right hand? Do you swear that the comments you're about to make will be the truth, the whole truth, nothing but the truth, I hope you God?
Thank you for the opportunity, Mr. Chairman, and as a matter of record, I did receive the option B information that was sent this afternoon.
I sent it to you, correct?
You did. Mr. Joe sent it to me, so I'm on the committee as well as the ad hoc committee. I have not had a chance to fully review it, so what my comments here are based on not seeing option B proposal. And I'd also like to say for the record that we haven't received a full specific impact study of option B either. So
I didn't even know that. I didn't look at, I just saw the letter, I didn't look at any of the attachments. Okay.
So option A, B, and C don't have information. So as you're aware, and as Beth has also pointed out, that the Township Committee passed the resolution to pursue option C at our regular meeting on August 16th. There's many factors that were considered in pursuing option C, right? I'm not going to get into all of those factors. And at the time, when we chose that, we made a recommendation, or followed the recommendation of the Land Use Board, to put 61 units on Fremont and 60 units on the proposed site. I still continue to support that option C, so if there's something else that's viable, but what I'm here to propose here tonight is a reconsideration of the split, and I have reasons for this. My recommendation is to revise the split to 71 units on and 50 units on down. So the split, again, was derived to say let's even disperse the units across town so that not one side of town becomes part of the reason, I should say, so that one side of town doesn't become the district. And also, it removes some of the financial obligation because almost the Fremont site is 100% responsible. So there's a financial reason as well as impact to the community. The other reason, one of the reasons we chose 61 is that in discussions with our professionals that there's this term that's been used in the sweet spot for what are unit projects with units that are typically, or I should say, we rephrase that, have a better chance of financing by development. And that unit range could be from 50 to 80. That was what was
Yes.
Yes.
So 61 fell in that range. So anyone can argue that any number in that range is a viable number because that's what is currently what we see in some of the information, at least that was told to us. So, and again, when we selected the split, it was also, at least my personal understanding, I'm not representing this as anyone else, that if we went out for an RFQ and the developer was to come back and say, listen, in order to get my financing on Fremont, I need to raise that number to, say, 7. That as someone who's wants to protect the interests of the financial interests of this town, we would consider doing that because it would secure the financing and it would remove the obligation of the town to the bond, which is a significant financial risk. So, if that moved, we thought then the Dow property number could move down. But that is not what I'm told now, that that's not something that could be done or easily be done.
So what?
That flexibility.
Right, so just, do you want me?
Yes.
So what Brad asked me was, could we put a range on Dumont, meaning 61 to 71 units, and then put a range on Dowell, the affordable units, which would be, help me here, 50
50 to 60.
to 60.
Yeah.
So the answer was, if you have a range, when you add the two minimums of the range, they have to equal 121, or Fair Share is not going to sign the amended agreement. So, and hence, Brad is now here, obviously proposing something that we're going to listen to.
It's a change, yeah, so, like, what I said, 71 on Dumont, the Dow thing. So, obviously, because the Dow property is inclusionary zoning, every unit you put over there adds an additional 4 market value homes to the township. So, if you get the number wrong on Dumont, and somebody comes in higher, and we're set at Dow, you now are going to build more affordable units, potentially, than were required. So, what I then asked for from Beth was to say, well, where does this sweet spot come from? Give us some data to at least, consume and project what's out there. So, what Beth shared with us was 2017 projects. And
Okay, the 2017 list from the, right, from the website of...
NJ, I think you're referring to those projects that received those low-income housing tax credits in 2017. The list of projects that were awarded or not is published by the NJHMFA annually after it does its allocation of tax credits.
And that's a public document which Beth gave to you, and the board can take, and the board can take judicial notice of it. That's an official public document, and it lists who was granted the 9% tax credits and who was denied, and in columns, it gives you parameters of the project.
Yes.
Okay. There's information on there, the number of units, the location, the sponsor, which is the developer, and some other information, the county, the township, etc. So I just did my own personal analysis on it. I looked at it, and what the data shows to me, there are, and again, this is 1 year's worth of data, and the units, again, you cannot make the leap that the project size is what's going to get the approval. There's so many factors that are going to come. So you cannot conclude that the units and the size of the project, the unit size, is the defining factor. Again, however, looking at the data, and considering the fact that there are all these other factors, there does seem to be a tighter range where you see these projects getting a higher success rate of approval. So I'll share some of the data points. 17 projects proposed in 2017. There were a total of 10 approved, so a 59% approval rate for that low-income housing tax credit. There were 7 projects with unit size between 50 and 65. With 6 different sponsors, the developers in that range. Only 3 of those were approved. So 43% of the unit projects between 50 and 65, which is a 43% approval rate. There were 4 projects with unit size of 81 to 103. Only 2 of those were approved. It's a 50% approval rate. There were 6 projects with a unit size of 66 to 72. 5 of those were approved. They had 5 different sponsors. So it had an 83% approval rate, had varying different sponsors and developers. So to me, again, I'm not concluding that the unit size itself is a determining factor, but it seems a little bit more than coincidental that the success rate in that range of 83% is a sweeter spot, in my personal opinion. It's not, I'm not an engineer, I'm not a developer, I don't know all the factors in my personal opinion, looking at 1 year's worth of data. So, from that, my proposal is to consider changing the split. The benefits of doing that, I believe, would be, it lowers the number of units sold to the township, because the Dow property would go from 60 units, which would be a 300-unit property, that would include like down to 250, or maybe a 50-unit reduction on Dow. It would also reduce the number of acres that would need to be zoned on Dow, because to maintain the 6-unit minimum, you would go from 50 acres down to 41.7 acres, which means less land that would be developed. And again, as a matter of opinion, my belief is that it doesn't increase the financial risk associated with the Dumont property, because we need to work with developers in order to secure financing so that these residents don't have to pay for it in addition to having the housing risk. So I don't think it raises risk, the financial risk. In fact, I think it probably gives us a better chance of securing it. That's just my personal opinion. So that is why I'm here. That's my proposal. I have the data, which is just the data that came from the public document, just organized in different ways so you can see the range and you can take it under consideration. And that's all.
Thank you. Another, can we go anywhere with that, or?
Something Francis, C-O-N-S-T-A-N, Francis, C-H-A-N-T-Z-I-F, 403.
You raise your right hand. Do you swear that the comments that you're about to make and will make will be the truth, the whole truth, nothing but the truth to help you God?
I have a general comment about shooting from the hip. Please disrespect it. I have been here spending a number of meetings. I have spent a lot of time doing work on behalf of the public here. You guys know what I have done. Okay, no need to speak. So I applaud the chairman tonight for recommending, or giving Mr. Frank the option, since he raised the point, to open the issues that we discussed, so to input from the public. But I was sadly disappointed that none of the people that were supposed to vote yes or no said yes. Now, we all have concluded through this saga that the public was never engaged. That's why we are where we are on the 11th, on the 12th hour, discussing options, which should have been considered a long time ago if the public was engaged. Or if you guys knew what you were doing. Or if you guys don't know what you were doing. Okay? So, shooting from the hip, it is very appropriate. You cannot make a proposal. You cannot, capital letters underlined, make a proposal ad hoc or make decisions ad hoc, okay, without input to the public or absent proper criteria and metrics. If you don't believe me, you do research into civil conclusions you will reach, okay? Because if you make ad hoc decisions, I can come in and say, guess what? I dispute what you're saying. Who is right? Who is wrong? From God? Of course not. Right? So, this is the key point. And you guys continue making the same mistakes. So, we have to learn from our mistakes. We want to continue to go forward and fix what's broken here. That's why all of us are here. There was no issues here. You guys were doing a good job. We won't come here. We're going to complain. We're going to go about our business. But we come here to assist you. But we don't even want our input. Just please take our input. Okay? So, that is my point. You can take it and put it in the garbage. But as long as I'm alive, I will keep coming here and hassling you to make sure you're doing a good job. Thank you.
Brian Dipton?
Can you raise your right hand? Do you swear the comments you're about to make will be the truth, the whole truth, nothing but the truth to help you God?
I do. I just want to make a few clarifications. First is, I do not represent the owners, as we sort of elicited to earlier. I only represent the contract purchasers of the properties, developers. Number two, we as developers, although it's been said several times that we submitted this, 3 hours ago, 4 hours ago, we've been talking with the town for over 2 months. This is not a surprise that we submitted it. My last deadline, I gave to Mr. Drill, was September 10th.
Right, your deadline was September 4, which you asked for an extension, we gave you September 10, then you said you didn't know when you'd give it, and then it came in at 3:15 for the record. Okay. Right, correct.
You can make comments when you're well done.
Go ahead.
My point is, I barely missed the deadline, but I did, it was for a valid reason. I was working very hard to try to put something together. If you look at the proposal, I have some copies people can have. We had a professional involved with a fiscal analysis. But essentially, Plan B is the following.
Mr. Chairman, This is irrelevant, in my opinion, to the housing element, if their share plan in front of the board. This belongs to the committee and the mayor and township committee. This belongs to the ad hoc.
All due respect, Mr. Gill, you can talk about my plan B all night. I just want to say what it is. It'll take me 1 minute. You want to hear it?
Okay?
Mr. Chairman,
You can say
Is
this.
there a problem with it?
If you want to hear from it, just tell them that you can hear from it.
Let's-
Technically, in my opinion, it's irrelevant, but you don't have to rule it irrelevant.
Let's,
I'm going to keep it to 1 minute.
okay,
A high overview.
let's do it.
Basically, what we're saying is we're going to satisfy 60 units, rental units, that put them all on the Furman property, which is next to the car dealership, on the other side of 173. We estimate that at about $15 million, not in exchange, but we plan to do the warehousing to rent funded. So the way that'll work is, we're going to pilot on the warehouses, the proceeds from the warehousing and the total fees from the warehousing will pay for the 60 units 100%, so it costs the township nothing. In addition, there will be additional proceeds, revenues to the township from the pilot. Not only will half the code get paid for, but then more money comes back to the township for whatever else you want to use. That's the proposal.
Whoa, what about the other half? That's 60 of the units. What
I'm
about,
giving my comment.
that's it? I
I'm
mean,
giving my comment.
okay.
Okay.
Okay, all right, I'm just asking a question.
Okay. Yeah,
Okay,
Can I ask you a question?
Okay.
That's the proposal. You have it now. I just want to
You don't have
know
input, I know, but I can...
And there is a fiscal analysis in here by Richard Redding, so it's substantiated as well. That's all I have. Thank you.
Okay, well, you're on the road, we get to ask questions. Can I ask them one question?
One question, John.
I just want to clarify, you're proposing to construct 60 rental units only and not the remaining 61 affordable units? Is that correct?
Correct. And if you read the
I didn't.
proposal, and if you read the analysis,
I didn't.
that's why you don't know.
Yeah.
You can't-
Okay, all right.
Okay, thank you.
That's for the other subcommittee
Yeah.
and the township committee, so, thank you.
Mr. Chairman. Thank you, members of the board.
Are there any other comments? Really?
No more affordable units? Only 60?
Oh, okay.
They took half.
Scott Ayod, 26 Red Hawk Lane.
Can you spell your last name?
Aydelottte.
Slower, please.
Aydelottte.
Okay, can you raise your right hand? You swear that the comments you're about to give were the truth, the whole truth, nothing but the truth, so help you God?
So I just wanted to read, there was a petition that was already sent through the Township Committee electronically about a week ago, and we wanted to at least share this and have it read into the minutes or tonight. So, we, the undersigned property owners of Beatty's Road, Barnstable Court, Red Hawk Lane, encourage you to adopt option A to satisfy the 2018 affordable housing mandate for the following reasons. One, 2015, the plan was adopted in 2015 by the committee members addressed more than satisfy the affordable housing requirements of Greenwich Township. Greenwich Township users paid monies to purchase the 14-acre Dumont Road to satisfy the 2018 affordable housing mandate. The 2015 plan was approved by all Greenwich Township personnel involved. There were no other options to the Demont property plan legally addressed or approved by any committee until August 2018. Suddenly, in August 2018, a new plan was adopted by the Mangus Committee and forwarded to the Township Committee that called for a split of affordable housing, 61 on Dumont and 61 over on Dow, with an additional 240 over on Dow. The Dow property had not been rezoned for the housing. Township master plan had not been changed to include residential housing on the Dow property. There have been no published site plans where the housing would be located or how many units. There have been no plan published as far as how the infrastructure is going to work on Dow, roads, sewers, and the like. The Township Committee has an October 15th court date to present the plan to the court that satisfies. So therefore, we urge the Township Committee, and again, this is something we've already sent to the committee, we just want to read it into it tonight. We urge the Township Committee to adopt option A
For the following reasons, the plan was universally adopted without contingencies in 2015. 2, the 2015 cites room for more units that are required in 2018. 3, we are required to provide 121 units of affordable housing. Option A more than meets that and will provide additional units based in 2025. And option C, which was approved in August, calls for an additional 240 housing units, more than the affordable housing mandate. Therefore, in conclusion, we'd like the Township Committee to adopt Plan A. We give the Township Committee to show the court that is going to adopt option A and present it to the court in October is not only meeting the court's mandate, but exceeding it as well. Thanks for your time. So again, you already, the Township Committee already has it. A number of people signed it. I just want to read this note.
Okay, thank you.
Good evening. Matthew Ian Snodgrass, 1611 Addison Road.
And I think I know how to spell it, but just in case, give it to me.
Snodgrass.
And can you please raise your right hand? And you swear the comments you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do. All right, many of you have heard me before. I've commented many times for the past 3 months about how we need to stay together as a community, right? So my big thing is one Stewartsville. It's one town. My address is in Stewartsville, yours is in Long. So we've been inviting people to get together for the past 3 months. Come together, figure out plans. When we came together, and we made C happen, basically because we figured out how to get more things added. That might not be good for your street, but it's good for the community. Because I don't know about you, but 121 units where there also is no plans, no studies, or any of that for us as well, probably won't do well, right? I'm talking to everyone. But when it comes down to it, as the facts were presented, 19 million versus 10 million, and then everything else, as, of course, Mr. Brill was able to give all of us the facts and professional opinion through these boards. It was a unanimous decision from the board to recommend to the TC, which also had a unanimous vote passed. So they looked at everything they could possibly think of to do this. So to go back to 121 units on one side of town, push it all on one side of town, and not think the entire town should shoulder this as a community. What, maybe 1,000 houses over in our area? Well, that would probably get many people back on the street angry, and we're probably pushing for B, because as we heard from B, 60 units won't be biased. So I can say right now that I will be able to get the backing for B if we go back to anything other than C. Thank you.
Where's the other 61?
Yes.
Yes. Doris Scullion, 13 Barnswell Court.
I know you spelled it before, can you spell
Yes, I
it?
certainly can, I still know how. G-U-L-L-I-O-N.
Thank you. You raise your right hand. Do you swear the comments you're about to make will be the truth, the whole truth, nothing but the truth, so help you God?
The Affordable Housing FAQ dated July the 10th outlines alternatives for satisfying the township's affordable housing obligations. The FAQ stated that the best option was to use land purchased by the township for the purpose of building 121 affordable housing units. This became known as option A. In August, the Land Use Board recommended that 61 affordable housing units be built on the township property and 300 multifamily units be built on a 50-acre tract of privately held land. 60 of these units would be affordable housing. This became known as option C. This is a complete reversal of the township's previous decision. No explanation was given for this reversal other than options B and C were, quote, presented to us, unquote, and pursuing option C was the government, quote, trying to help you, unquote. In keeping with the board and or the councilman's commitment to quote, providing full transparency in each and every undertaking, unquote, we ask at the very least that someone answer the following questions. A, what is the genesis of option C? In July, it was only an abstraction. Now it appears to be a true option. Maybe. We don't know that now. B, why did the Land Use Board recommend abandoning option A? C, as perceived by the board and not their professionals, what are the benefits of option C over option A? D, has the board considered the fact that option C will increase the supply of housing units in our township by 19% over 2016 numbers? These numbers are dramatic, especially when one considers that housing units in the township have increased by only 5.3% in the 6 years between 2010 and 2016. E, does it make sense to the board to forego the opportunity to limit short-term growth to only 121 units? Has the board considered the impact of an additional 300 students on the township schools? Can our schools handle an additional 300 students, an increase of almost 41%, along with additional payments to Phillipsburg High School? Has the board asked the superintendent of schools to analyze the impact on the township schools and to assess the costs associated with this 41% increase in enrollment? Have potential cost increases been assessed by other township officers, such as the police chief, the head of the Public Works Department, the township CFO? Until these and similar questions are answered in a public forum, I ask that no further action be taken by the Land Use Board or the Township Committee with respect to option C. My remarks tonight included questions and comments directed to the mayor and council in 3 emails my husband and myself sent. We attempted to copy members of the Land Use Board and were told that this was not permitted. I would ask that copies of these emails be incorporated into the records of this meeting.
You need to read them into the record to get them in the record.
Here we go. We are writing this email. This was to the mayor and council. All of them.
Right, but you're not directing these emails to the Land Use Board.
Okay, so to the Land Use Board.
Right.
Got it. We are writing this email to ask you and your colleagues on the council to provide more transparency regarding affordable housing. We just learned by the neighborhood grapevine that there is a proposal for 300 new units on the Dowell tract adjacent to Beatty's Road. Upon learning this, we went to the township website and reviewed various affordable housing documents. This was sent on Tuesday, August 28th. The Affordable Housing FAQ dated July 10th, which, as you know, delineates alternatives for satisfying the township's obligations to provide affordable housing. This memorandum stated that the best option was to use land purchased by the township for the express purpose of providing affordable housing. This option minimized the number of units to be built, minimized the burden on the school system and the infrastructure, and avoided negotiating a quid pro quo with the developer. Additionally, this option had the necessary agreements with FSHC. This same FAQ memo stated that the township opted for this plan and that it was unwilling to allow the creation of additional housing units to satisfy its obligation. The Greenwich Township Land Use Board Resolution dated August 8, 2018 recommended option C, development of 50 acres along Beatties Road for 300 multifamily units, 20% of which, 61 units, would be affordable for sale units. Now, those appear to be rental units, is that correct?
Along Beatties?
On
the-
Beatties, correct.
Does the housing plan and the zoning that would be adopted to support that would not specify for sale versus rental? We're not able to do that in zoning.
All right. Plus the 60 units, plus the 61 units on Greenwich. Based on the review of these two documents, we are greatly distressed with the lack of details as to what is currently being contemplated. This is a complete reversal of the township's publicly stated position. The fact that this reversal occurred within a month of publicly stating that the township was unwilling to allow the creation of additional housing units is alarming. Equally alarming is the presence of a written, publicly articulated, and published rationale. Until this happens, we strongly recommend that you and your colleagues suspend all efforts to pursue option C until a factual memorandum of the details and ramifications of option C can be disseminated and public hearings held. Respectfully submitted, Bill and Doris Gullion, 13 Barnes Swallow Court. Email Wednesday, August 29th. In our continuing effort to understand why the township abandoned the previously announced affordable housing plan, option A, we watched the video of the August 16th Township Committee meeting. Option A had been in development over a considerable period of time. Property had been acquired to implement this plan, and necessary agreements had been finalized. In the August meeting, it was announced that subsequent to the July Township meeting, options B and C were presented to us, and resolutions were made to facilitate and pursue option C. It was briefly noted that option B, which involved striking a bargain with the developer to build affordable housing in exchange for permitting warehousing, was also still on the table. Nowhere in the discussion were the particulars of how and from where these two options materialized. Also, there was no reason set forth as to why option A was abandoned, other than Mr. Marchetta commenting that this was the government, quote, trying to help you. Regarding option C, first, the public discussions and documents available regarding this option fall far short of fulfilling the Township Committee's mission statement of, quote, providing free transparency in each and every undertaking. Second, absent any explanation, option C is, on the surface, nonsensical. Why build 360 units when the mandated 121 will suffice? 360 is nearly 3 times what is actually needed. Why increase threefold the burden of increased educational expenses, infrastructure costs, and an inevitable rise in property taxes? Yes, that the land use board be more forthcoming regarding options B and C. Until this happens, please take no further action in regarding options B and C. And there's one more. Are you ready?
Yep.
All right. Sorry. I apologize to everyone. I'm sorry. This is the only way to get these in.
Just to understand why, because it's a public hearing.
Yes, I do.
Right.
Of course. Okay. This is Friday, August 31st. To the land use. Using the most current data, the housing units in the township increased by 97 units, 5.31%, from 1,828 units to 1,925 units between 2010 and 2016. Option A will increase the units by 121, 6.29% over the 2016 number. Option C will increase the units by 360, 18.7%. These numbers are of a magnitude that will impact the entire township, not just the residents on New Barnway or Beatty Road, but the entire township. The data used is from the U.S. Census Bureau. These numbers come with a significant margin of error. Presumably, the Land Use Committee and Council have access to much more accurate and timely information. One would hope the Land Use Committee utilizes this information in a rigorous analysis of the impact of Option C before recommending it to the Council. If so, would the committee share this analysis with the public? If not, will the Council, one, undertake such an analysis, and two, share it with the public? A major difference between Option A and Option C is that the growth associated with Option C can, in the short term, be avoided. Future growth, while it isn't inevitable, can and should be planned for and managed over time in a manner that maximizes the potential of change and minimizes the negative impact. This appears not to be the case with respect to Option C. Option A, on the other hand, is a fully developed plan that should be implemented. Additionally, we ask that the Land Use Board take no further action with respect to Option C and take every action possible to maintain the viability of Option A. Thank you for your indulgence.
Do we have any more comments? Yes, we do.
My name is Anna DeGesso, D-I-G-E-S-O, Superintendent Office.
Can you give me that last name slower, please?
D-I-G-E-S-O.
Okay, can you raise your right hand, and do you swear that the comments you're about to make will be the truth, the whole truth, nothing but the truth, so help you God?
I guess from hearing some of the comments here, it's apparent that there's a lot of misinformation, and I, along with several people in this room, have had the benefit of attending these meetings since the beginning. And I just want to comment on my understanding and see that a little bit more correctly if I'm wrong in anything. Option A, B, and C involve building at least 61 units on the
Correct.
A, B, and C as building on the
Correct.
With option A, 121, with option B and C, 61.
Correct. Yes.
With option A, with 121 units, because it's a municipal-sponsored plan, if the township does not procure a developer, the township is on the hook for those 121 units, which I believe was estimated will cost the township $19 million.
Correct.
Yes.
In addition, the density of the 121 units on that plot of land,
On the 14 acres,
14 acres, average to be about 12, correct?
Yeah, in that neighborhood, roughly 121 units on 14 acres, it may 11, 12 units an acre.
And we all know the affordable housing units in Greenwich Place currently.
Yeah.
I believe the density was around 6%.
I thought it was,
Both of them are around 8.
I thought it was
A little
8.
bit higher.
Yeah, I thought it was 8 and some change.
So if anybody has driven past the affordable housing units, you see how dense those units are. So 121 units on Fremont is going to be 12 versus 8.
Wait a minute.
Ma'am, it's not.
No,
Just the math is, it's 8.5.
It's 8.64, no?
Yeah, 8.64.
8.64 units an acre for 121 units on the 14 acres. And Greenwich Chase is somewhere about 8.4.
Yeah. The density of the lots down on Revere Road,
Phase
we call
4.
the COA section of Greenwich Chase, yes.
Greenwich Chase Phase 4.
Greenwich Chase Phase 4.
That was the first one.
That's
You
what
know,
I'm saying.
The density components are very equivalent.
you had everything else on the money.
So, now going to option B or option C, regardless, the township has to build 61 units on Fremont.
Yes. That's correct. Well, not under B,
No, none of it.
not under B.
Well, 61 units still have to go on Fremont.
Yes.
Yeah.
So, again, our understanding of option B before Mr. Tipton, changed it, because again, okay, I'm guilty, I didn't read his letter because I got it at 3:15. But our understanding of option B was that they would be building the 61 units at Dumont, and they would be responsible for producing the 60 units at Dowell with no market rate units.
So let's just say the 61 units, would not be built by the, on Fremont, for option B. If that's the case, and for either option B or option C, if the township cannot procure a developer with option B and option C, the collective township would be $10 million.
Roughly, yes.
Roughly $10 million versus $19 million with option A. So it's almost-
Yes.
And then, if it was agreed upon with option B that the developer would build the units on Fremont, there'd be no cost at all to the township.
Presumably, yes. They would fully fund the development under that scenario.
Okay. So, it was from my understanding that with option C, the benefit to that is that if we can't procure a developer, our liability would go from $19 million with option A to $10 million.
Correct.
The township would be on the hook for that money. And in addition, in terms of the amount of students that would enter the school system, I believe that you did an assessment on that, and it was 100.
Beth's going to look at it, Beth is going to look it up on her laptop and give you a precise answer.
But it was not 300.
Yeah, that does sound familiar, but I'm going to need a minute to put my fingers on that figure once again.
Technically, this is comments, you're asking us to correct it, we're not correcting you on that one. Keep on going.
All right, but it was in that range. It was
Yeah.
120,
Yes.
130, something like that, not 300. So the township would not, gain 300 students with option C. And then my last comment is, with option C, the 61 units still have to go on Dumont regardless. But as far as the development on Beatty's Road, that doesn't necessarily have to happen, just the zoning has to be in
The
place.
zoning has to be in place to create a realistic opportunity, otherwise Fair Share is not going to sign an amended settlement agreement with us. Once the zoning is in place, that's the extent of the township's responsibility.
But that does not mean that there will be anything put there, just that the zoning has to be in place.
Yes.
And,
You did a very good job.
well, I mean, like I said, many of us have been here from the beginning, so we've had the benefit, of learning all this information, and for those that are just coming on board now, there's a lot of information, and so I just wanted to clear it up so that clear it for myself as well.
I thought I just did it.
I'll find out,
Thank you.
Okay, you said comments, you're right.
Thank you.
Thank you.
No, you gave your, can you give
One
us,
point, Gary, one or two pages left.
okay, and can you raise your right hand? And do you swear the comments you're about to make will be the truth, the whole truth, nothing but the truth to help you God?
So, this is both the board and the actual residents who are here who care about the growth and the potential of what could happen here in Greenwich Township. In reference to, I believe it was Costas, I don't know if he's still here, and he walked out. He started it off very nicely, and he talked about the business exceptions of this whole project. Mr. Snodgrass stood up and talked about Greenwich as one. It's a little bigger than what we're talking about, option A, B, and C. Everybody needs to just think about what happens to the community, okay? There may not be no right answer, no actual correct answer here. But what I have to say is, I myself personally reviewed many of the documents on the website, okay? The videos, previous meetings, disturbing theme has kind of come about here. And that is, exactly what Costa said. We're not getting our options across, we're telling what we want as the residents who elect the people up there. We have to work together, both communities, to come up with a happy medium or decision, okay? There's been many of items that people have told me about prior to the meeting and previously in telephone calls about other options they would like to see, which I actually think are pretty good ideas. Basically, our township officials and even the land use board members are given many of these items at the last minute and relying on our township planner and land use board attorney to guide them through their decisions. All this happening without residents having the proper forum to speak, whether in person or remote. My concerns become more evident when I watch these videos and hear valid questions being asked by both residents and township officials. I see many of these quality questions being dismissed by some members and professionals. I have seen questions answered by both our professionals and officials with best guesstimates or rough figures. I have seen overall financial obligations from 19 million to 12 million to 10 million, and even as low as 5 million. I noticed the answer to a so-called sweet spot is 60, given to the public without any backup data. It's evident that the volunteers who sit on these boards and committees have jobs and families outside of what they do. They only have periodic monthly meetings to make these decisions, and they're giving them hours, sometime a day, before they can make this decision. This is a forum to have an informed residential decision from every person who pays taxes in this town. And this is not a grass edit. We have to work together. I'm willing to do it. We need to set forward what we're going to do. I noticed here that there's attorneys in the room from the developer, and they magically come up with an option B as the deadline. The option B is obviously a scare tactic. It is what it is. We have to work together. We have to figure out what it is. Whether it's the township committee who has to put together a subcommittee, but this timeline is getting ridiculous, whether we have to ask for an extension. We can't rely on professionals all the time and just look at only what they provide us. We have to sometimes think outside the box. That's all I have to say.
Anyone else?
I'm back.
Name?
Tim Mason, 14 Barnesville Court, Louisville.
Okay, raise your right hand. Do you swear that the comments you're going to make will be the truth, the whole truth, nothing but the truth, to help you God?
I do. Okay, so, I know this has been going on for a little bit of time. I just want to read something into the record as Mike was asking me to. And we had discussed this prior to the meeting. And that is, if any, assuming something is built, using option C, that we would like the scenic corridor 200-foot buffer instituted to preserve our environmentally sensitive area and community in that area. So I want to make that part of the record. I would also echo Mark Monicari's comments and just say that I do feel that things are happening very quickly, so quickly that I feel like it's getting ran down our throats without proper planning and without proper input from the community. Therefore, I believe that it is causing a lot of friction because there is not enough time to get it together before the so-called deadline that we're trying to meet. I find this very detrimental to the fairness of the decisions that are being made. So with that in mind, I'm not sure if there can be anything done with that, because I do understand that there is an agreement with the court. Is there anything that can be done with that?
Yeah, this is comments, not questions.
Okay,
Sorry.
I'm just trying to help out here.
I understand.
And I guess just keeping in mind that when we're making decisions, that I noticed that one of the goals in the facts on the township website is to encourage the targeting of new housing to areas with compatible existing densities and within walking distance of schools, employment, transit, and community facilities and services. Again, I don't know if enough discussion's been given to this or some of the other issues that are involved with the amount of housing that we're talking about being divided amongst the entire township here. So I definitely think that it bears more discussion before making a hasty decision. Hopefully not a decision that we're going to regret in the future. Thank you.
Anyone else? No?
Roger Bagley, 106 Beatties Road.
B-A-G-L-E-Y?
Correct.
Got one right. Raise your right
It's
hand.
an easy one.
Yeah. Raise your right hand. Do you swear the comments you're about to make will be the truth, the whole truth, nothing but the truth to help you God?
All right. During this meeting tonight, we noticed, and they spoke up here, the attorneys and the developers. They do have a plan B, as you're surely going to show it as soon as you read it. And from what I just saw, it is ridiculous. It covers the whole property with about 1,000 truck bays. Now, if you guys are considering this, I tell you,
Again,
that's nuts.
again, this option B, I know maybe,
Okay,
it's not part of the land use element and fair share plan that's on for the public hearing for adoption tonight. That proposal is going to be sent to a committee that the township created to evaluate that, and that's going to go to the mayor and township committee, and that's where you should direct those comments.
Okay, we'll have a week to figure that out, right?
Yeah, I believe their meeting
Next
is...
Thursday.
When?
Next Thursday.
Next Thursday. And for the record, they had a deadline of September 4, which they couldn't meet. The committee extended it to September 10th, and then they said they couldn't meet that, and they couldn't tell us when, and it just came today. So I apologize if I didn't read it, but it came in at 3:15, and I had to drive out here. Okay, but it's irrelevant to this proceeding.
And also, if it ever comes to Plan C, I would hope that you would make it so it's aesthetic looking, and, there's some proposals to put those houses, maybe 50 feet off the Beatties Road, 3 stories high. I mean, what the heck, We would like it to be like you had originally planned, to have at least a buffer of 200 feet. So when I look out my front door, I don't see these big square houses that are all connected like apartment buildings. I didn't buy my house to have that, and it was never in any of the master plan that we've looked at since we moved in. Never any warehouses, that's for sure. Thank you.
Thank you. Okay. Well, anyone else? Okay.
My name is Joseph Caban, C-A-B-A-N.
I'm sorry, can you talk louder and spell it slower?
Absolutely. Joseph Caban, C-A-B-A-N. I live at 21 Red Hawk Lane.
Okay, raise your right hand. You swear the comments you're about to make loudly will be the truth, the whole truth, and nothing but the truth to help you God.
Yes.
Thank you.
I like all the comments that were made about us being one Streetsville and coming together as a community. One comment I'd like to make is, the way I see the plan figured out, I don't think it's fairly adequate. And we're going to have to deal with a large number of homes. I would ask that we consider, particularly Plan C, that we did those market rate homes, people in the middle of some affordable housing is figured out.
Thank you. Anyone else? No, one more.
John Creighton, Cherokee Tractor Mill,
Spell the last name.
C-R-E-I-G-H-T-L.
Raise your right hand. Do you swear the comments you're about to make will be the truth, the whole truth, nothing but the truth to help you God?
Yes, sir. A couple comments. I think the first part of this meeting,
just total nonsense in the sense that you already agreed for option C, and the township agreed to that option that you recommended to the township committee. Now, I'm not sure if they came back and reviewed every different potential slice and dice of the Dow property.
Because we were asked to.
Well, you're trying to use the township. You really already approved it.
No. If the, under the municipal land use law, if the township committee refers something to the board, under the MLUL, they make a recommendation. Now, if they had no recommendation, I suppose they could say, we don't have any preference. The mayor and council did not choose that site option 1. They said it was their preference. They asked the board to make a recommendation. The board, under the referral powers, you heard them go through, and they made a recommendation. They came back with, we recommend site option 1 with a backup of site option 2. And the housing element and fair share plan, in my opinion, does not need to select the 50 acres, but the ordinance has to. It's required. You can't do option C without picking the 50-acre slice. So this board got referred to it from the township committee. They had no choice. They got to make a recommendation. That's what you witnessed in the beginning of the meeting.
But that was, in my mind, that was already part of the meeting.
No, it wasn't. It wasn't. The township committee indicated a preference for option 1, but they asked the land use board to make its recommendation. You heard the land use board. They happened to agree with them, but that's what you witnessed.
And I thought that was the end of it, until all the slice and dice of the Dow property, which kind of in a way,
No.
might be talking about. Anyway, that's just one thing. The other comment is, the timeframe is so close to October and November that, to me, B and C aren't going to happen. I mean, it just doesn't logically make sense that either B and C can come to a decision fast enough in the township, and they have everything done. So, in all fairness, I think that the town is correct. They shouldn't have to have all the 121 units on one side of the township. But that's what you have right now, unfortunately.
Correct.
The other comment I had is brought up about the potential, I think you mentioned one of the properties, free property plan B, with all the residential conservation district being rezoned.
That's
crazy.
Listen.
I'm not aware of any such
Apparently it must be in the proposal that they submitted that I haven't read.
You had mentioned one of the properties.
Which property?
The Santini property is in the RCD zone.
And Furman.
And the Furman property is in the RCD zone. Now again, I didn't read the proposal.
We don't know if that's part of the proposal.
I heard what the attorney said, and then I took a quick look through, and that's part of option B, but that's not in front of the board tonight.
I'm just saying, that sounds crazy.
Okay. No comment from me.
Right. Anyway, I just want to thank you for doing good work. Thanks for this.
Thanks. Anyone? Brad, we're not doing seconds.
One more time.
Listen, it's up to the chair, and then the board can overrule them. If they allow you for seconds, then they got to allow anyone else for seconds.
Do you really want to do that to us, Brad?
It's 10:15. It's 10:15. It's 10:15. It's up to you. You know, if you say yes to him, you can't say no to anyone else. I'm just telling you.
Brad, sorry.
I will make a motion to hear Brad and anybody else.
Someone going to second?
No, you have a second.
Someone going to second? Everyone in favor?
All in favor of continuing?
Okay, Brad, you're up.
Okay. Thanks, board. No one else can ask anything.
No, anyone else can go for seconds now.
All right. Well, I apologize. I'm sure everyone's here. I want to clarify the 6th. I know that was a question about why there was 6 views. If you guys want to point fingers, I'll take all the heat on this one, because at the last township committee meeting, when we had to go forth with option C, and the recommendation was we had to I'll use my own terminology here, John, tentatively take a preference of option 1 or 2. We had 2 presented to us. I had and expressed it at the meeting, reservations about picking the theater. I'm not a land developer. I don't know what's a better site, and I didn't want to do it. But to put there, and I specifically asked Mr. Bill at the time, I said, do you take an option? Are we locked into this? And his answer to me was no. I said, okay, fine, we'll go with the preference. In the meantime, I'd like to see and explore, we only were presented with 2. What are other ways to choose the 50 acres? So part of the reason why there was 6 tonight is because I asked that question. Because I wanted to know what are other ways you could lay this out for consideration. So that's why there was 6. We didn't lock in on option 1 at the last meeting at the township committee because it was expressed that we could change it. And I don't know if it's still possible if we change it later on, but that's, I'm just explaining why there was 6 options. If you want to point fingers, you can blame me for it, I'm fine with it, but I'm just saying it was just a very difficult decision to make in such a short period of time, which was literally like an hour or 2 to say, which one do you prefer, 1 or 2? And I'm like, it's a very difficult decision to make in that short time, so I wanted to see it. And now I've had their look at it, we've got a lot more people who are more experienced than me at this. And now they can make a recommendation that will send to the session.
Anyone else?
Anyone else for the second time?
Anyone else? Okay.
Close it.
Can I have a motion to, we have to make a motion to close the public hearing. Motion from Jerry Hill, second.
And by the way, you guys aren't adjourned, you're voting.
Right. And second was, Kathy, okay. All right.
Public hearing's closed?
Public hearing is closed.
All in favor? Aye.
Of what? So someone make a motion to, is someone gonna make a motion to adopt the amended housing element and fair share plan?
We're closing the meeting. We didn't vote on closing the meeting.
What are you talking about?
We need a motion and a second.
Yeah, you close the public, that's all.
All in favor of closing the public meeting? Aye. Okay, now we're done.
You closed the public hearing. You didn't close, okay. I was hearing you closing the meeting, I was like...
No, we're not.
Okay.
Okay. So, now, pardon?
Hey, folks, we're still actually
still
conducting
meeting.
our meeting. If you
Yeah.
could try to keep it down a little, please.
Take the conversation outside or stay here and listen, either way.
Can you guys take the conversations out in the hall, they have to deliberate?
They may want to stay in our public, our...
Oh, they certainly
They're
could stay,
welcome to stay. We're
absolutely.
not kicking them out.
But they,
They're the ones that want to be here and they want to hear us.
Right.
yeah,
We're not kicking them out.
no, stay.
They should stick around and hear us.
Okay, so, the next first of business is to adopt a motion to adopt the amended third round housing element and fair share plan. Is that correct?
That's correct.
Okay.
Can I ask a question first or no?
Yes.
Okay. If we don't pass this, what's the ramifications? We heard
If
a
you-
lot of pleas not to
Right.
pass this.
If you don't adopt it, you have option A. You have the existing housing and fair share plan, and if you don't adopt this change, then barring some settlement with option B by October 15th, where we have a signed fair share amended settlement agreement, you have till the township has till November 15th to adopt the ordinance for the 121-unit, 100% affordable housing project. If you do adopt this plan, you're not abandoning A, because this plan was specifically set up and worded in such a way that it only applies if the township and fair share enter into an amended settlement agreement. Then, option C kicks in, and it's 61 units on Dumont and 300 inclusionary, 20% set aside, 60 units, or you could adopt this, but someone can amend it to change the split to what Brad Perone suggested. And instead of 61 units at Dumont and 60 units at Dowell, that you increase it to 71 units at Dumont and 50 units at Dowell. And someone, in my opinion, could make a motion, and you could adopt this plan with that amendment, and you wouldn't have to represent it and have a new hearing. So you've got 3 options.
Let me just summarize it. So we could adopt option C as is, We could adopt option C with Brad Perlin's comments to redo the splits, I think it was 71 and...
71 and 50.
50, or we could not pass this, and then option A is stands.
Right, correct.
So if you pass C, we include C.
Hold on. If you adopt the amended housing element
Yes.
and,
And the landowner sues us, we're back to A.
well, no.
No?
If you adopt the amended housing element fair share plan, and fair share doesn't agree
Right.
to sign the amended settlement agreement, then you're back to A. If fair share agrees to sign the amended settlement agreement, on the thinking that it's still realistic, that's just a negotiating ploy, they can sue, the developer or Dow could sue the township, but like Beth said before, correctly so, we keep on going on our way until and unless the court rejects it. If you adopt the amended housing element and fair share plan, and it doesn't matter to me if the split is 61-60 or 71-50, either way, if you adopt that, it kicks in if there's an amended settlement. And I told you right up front, that right now, whereas last week, I would say I was 99% confident that you would wind up with a signed amended settlement agreement. After the email, I was like 1% confident, and then after their letter, 50-50. But if you don't adopt the amended housing element and fair share plan, you are choosing A. And by the way, it is your housing element and fair share plan.
Yeah.
It's not the township committees. They would have to endorse.
Either they can say yes or no, right?
No, they've already endorsed the prior housing element and fair share plan.
Yeah, so it stands.
It stands. What they would have to do is endorse, if you adopted the amended housing element and fair share plan, they would have to endorse it. I suppose they could say they weren't happy with the new split, if you went to the new split, and then we'd have to deal with that.
If we don't pass this, if we don't pass option C, and A stands.
If you don't pass the amended housing element,
The amended plan, which is option C.
well, it allows for
Only
option
C, it allows...
It allows for C.
If we don't pass the amended plan, and the township committee doesn't like that,
Right, the township committee, in my
we can say,
opinion,
who cares?
could still, okay, what's the significance, right, of the housing element fair share plan? It's really twofold. First, it is a planning document. The second significance is ordinances that are adopted have to be consistent with it. However, if they're allowed to be inconsistent, if the township committee does two things. One, they'd have to, with their motion to adopt an ordinance that would be inconsistent with the housing element and fair share plan, they'd have to also adopt a statement of reasons explaining why they were doing something that was inconsistent with it. And the second thing is, then the vote on the adoption of that ordinance requires a majority of the full membership. So, there's 5 members of the Greenwich Township Committee. If all 5 show up in a meeting, a majority vote is 3-2. If you didn't adopt the amended housing element and fair share plan, and they disagreed with you, and they adopted, let's say, for hypothetically, an MF2 ordinance, which had the option C in it, in any event, they would have to adopt it with a statement of reasons of why it's not consistent, and if all 5 are at the meeting, still 3-2 would do it. But if 2 people are absent, there's only 3 people at the meeting, it needs all 3. If 1 person's absent, and there's only 4 people at the meeting, it still needs 3. But although if you had 4 people, it would need 3 anyway. So I guess if 2 people were absent, 3 people alone could not adopt an ordinance being inconsistent. Have I thoroughly confused you, or do you understand?
Pretty much.
Let me try it again. Let me try it again.
We got it. We got it. So, our options here are not adopt it, adopt it, or adopt it with amendment.
Right.
Okay?
Of those two numbers.
The split.
Yeah, so what are the feelings about adopting an amendment to the number?
Yeah, why don't you deliberate and get everyone's feelings on it
No,
first?
I don't understand. If we don't adopt it, the township committee can't adopt something else.
Yes, they can.
They can create ordinances that are inconsistent? Is
Yes,
that what you're telling me?
yes, they can, but they have to also do a statement of reasons of why they're doing it inconsistently of the full membership.
Okay, I'm just trying to understand that. Okay,
Yeah.
thank you.
No, that's opinion on what Mr. Barone said. What's your thought
On the alternative split,
Yes.
I think that the split between the two sites needs to be something that the community is comfortable with. I'm not convinced that adding or subtracting 50 units to the Dumont site, the addition of the 10 units to go from 61 to 71, is necessarily going to be a trigger for funding that might not otherwise have been received. What's more important is the level of comfortability that this board and that the township committee has about either 50 or 60 units on the Dumont site, or 250 or 300 on the Dowell property. My professional planning opinion is that I'm comfortable with both scenarios. I think the Dumont Road property is the number of units, whether it's 50 or 60, is within the range of...
Whether it's 60 or 70.
60 or 70.
Yes, I'm sorry, 60 or 70 is within the range of fundable projects, if you will, and I think 250 housing units instead of 300 units is still an appropriate-sized inclusionary development. I don't think it endangers the feasibility of that project, or either project. So, I hope that's helpful, but they're close enough that I'm comfortable with it, and I think it really comes down to, how does the community feel about this? Is what's more important, the additional 10 units on that property and the impact that may or may not be felt from that, versus the additional 50 units on the Dow property and the impact that may or may not be felt by that.
And when you talk about financial risk, on the one hand, so when Brad said, and I'm not taking a position on either one, but when Brad said, in his personal opinion, he acknowledged he's not an expert, that it would lessen the financial risk based on looking at the form, based on looking at the spreadsheet of the awards for the 1 year, it would reduce the risk of losing an award. On the other hand, you could look at it, if you do lose the award, it increases your exposure.
Yeah.
But that's what, I agree with Beth, that's what you have to grapple with.
Yeah.
If she's saying that, over the whole scope of things, you're gonna find out when you put out the RFQ, if you gotta go, up or down.
That extra 50 units on
I understand.
There's been a lot of discussion here and elsewhere about the 60-61 split being fair, distributing that, through the town. But to me, it's, you're distributing the affordable housing through the town, but you're creating 61 units one place and 300 units someplace else. So I think you have much more of an impact from that than the 61. So personally, I don't have a problem with the idea.
Personally, as a
board member, I don't have a problem with increasing the Dumont Road by 10 units to get 50 units less on the other part.
I think you should all pull yourselves on this.
There's why can't we hold it so that range is in there?
Right.
So that's the ticklish.
Here's the problem.
We add the statement that we need a total of 121.
So one thing, for the range, keep in mind that the minimum of each range, because it'll be arranged on both properties, has to meet the total obligation. So we would need a total of 121. But in addition to that, so the thought is, you might provide a range on both properties, right?
Provide a range and another clause that says the total.
So, but we can't anticipate, so for the Dowell property, the problem is that
Can I make it
most
very
likely,
easy? Fair share, I've discussed this with them. Unless the two minimums add up to 121, they're not agreeing.
Right.
I don't even know, as we stand here, if they're going to still agree after the Dowell people have objected and sent the email. But assuming we get past that issue, if the two minimums don't add up to 121, they're not entering into an amended agreement.
And I don't think that folks should anticipate that a developer of the inclusionary site is going to want the lower range of units.
Right.
That developer is going to say, you know, I can do 250 or 300 units. Most likely, they're going to select that 300 units, and so the range is not going to be particularly helpful. And then, so I'll just leave it there.
So let's get a straw poll. Who would be in favor of changing the split? And let's get this right, it would be,
The split would be, right now, the split as set forth in the draft proposed amended housing element fair share plan is 61 units at Dumont and 60 affordables at Dallas. So what you want to know is how many people would be in favor of going with Brad's suggestion of 71 at Dumont and 50 on Dallas.
Can I ask, before we get to that, do we have does anybody here have any appetite for just not adopting anything and going with that?
Why don't you poll you on that first? Is anyone, in other words, what Dawn Marie wants to know,
I really want to know.
is anyone in favor of rejecting the amended
Yeah.
housing element and fair share plan?
But this is a straw poll.
I understand, straw poll. Who's in favor of rejecting it? One,
Are you rejecting what?
with not adopting this amended housing element and fair
which
share
would by
plan.
default mean you're at A.
Yeah.
Right.
So,
Do we want to change the characteristic of this town for just that 1 second?
I understand, so let's poll.
And we also need to understand is that a list of $19 million, if we don't get phase one, it's $10 million. You know what I mean? Like, there's a financing that's been mentioned a couple times.
Okay,
by
so,
the township.
again, by a show of hands, who is,
What I'm just saying, it's not exclusive, so you could be torn between two, and I understand that. So when we take a straw vote, if it ends go up, you can understand that.
the straw poll is who is opposed to adopting the amended housing element and fair share plan? Straw poll, opposed to adopting it. 1, 2, 3, 4.
You know, I'm missing somebody.
Oh.
Whoa, where did he go?
Yeah, I think he went to the bathroom.
Okay, we gotta get him back.
Oh,
You gotta wait.
this is the,
So, what, we still have
I think you should wait for him to come so he can hear it.
Because I'd like to have that discussion.
Can you go try and...
Somebody's not going to
Better you than me.
Because I really have to go too, if I'm holding it.
I hold it on a nightly basis. I've learned.
I'll consider myself a rock star.
For the people who stayed, you stayed for a goodie, okay? Everyone assumes, it's a rubber... These people are not a rubber stamp. They actually listen. Status update?
Fans on, so.
When he comes back in, no one applauds. You can't have fun, right? Oh, Mike's gonna try to get going?
I'm never taking a bathroom break. Never.
Oh, my God.
Maybe the lesson is here, we should have taken a 5-minute break for everybody.
Can't make this stuff up.
We probably should have, yeah.
Yeah.
Except I thought we were gonna wrap it up pretty quick.
Oh, you're so optimistic. There we go.
I am sorry about that. What happened was, I didn't notice that you had left the room.
Oh, I'm sorry.
No, that's my bad. I didn't notice it. And so, the board started a bunch of straw polls. The first straw poll is, and Dawn Marie asked, what are the options?
Yes, I was here for it.
So did you hear, one option is reject it.
Yes.
One option is adopted as written, and one option is adopted amended to what Brad said. So we just started the straw poll of who is opposed to the amended housing element and fair share plan. Okay, so who's opposed to the amended housing element and fair share plan? Raise your hand.
Which by default means Plan A.
Right.
Okay, just to be clear.
Who's opposed to adopting the amended housing element and fair share plan? Raise your hand. 1, 2, 3, 4. That's where we were, and then we said, uh-oh. Who is in favor of either the amended housing element and fair share plan as written or amended pursuant to Frank Barone? Raise your hand. Brad, I'm sorry. Brad Barone. You realize what I'm conflating. 1, 2,
Your hand doesn't count.
3, 4, 5. So, yeah. Okay, so, the housing element, the amended housing element and fair share plan has not been rejected. So now, the straw poll,
We can discuss this now.
yeah,
I'd like to know what some of the rejected thoughts are.
Well, here's the deal. The 121 units on Fremont, okay? 60 are gonna go across the street. And with that, we're gonna get warehousing and possibly...
whoa. No.
Well, Plan B, okay.
We're not talking about Plan B. This is Plan C. Sorry to yell at you.
Long night.
It's not so much the affordable housing being split, I don't have a problem with that. It's that extra 240.
Right.
And as much as we could say we can't talk about B, we may not have B. But let's face it, the door is open, okay, and warehousing has been attempting to come in. That area, it'll change the landscape, not just for those people, but for this town.
Right.
Okay, I'm not saying pro or con warehousing. What I'm saying is the cost of the split, I always say is way too much. And I spoke to a couple of you folks. I really don't like the split zoning. And I really don't like it and that was before there was an objection. I voiced my impact, voiced my opinion that, you know, without the owners okay, I just don't like coming on somebody's property and saying, well, 50 goes here and us. And it's always been niggling with me, even if I voted for it, it just bothers me. So that's my opinion.
Yeah, I agree too. The extra housing that comes with the split is what I don't care for.
Can we move on to a discussion before we straw poll on whether to adopt the amended housing element and fair share plan as written versus as proposed to be amended for the split pursuant to Brad Perone's suggestion? Can you guys start to discuss the pros and cons of...
Well, my thought on that was, with the amendment, is that while, yes, A is still there in the event we have to fall back on it, but it still allows us C, if that were to, because it seems like with the last 3 meetings, it's, you know, kind of mushroom cloud and then went down and then mushroom cloud again, and it kind of keeps going back and forth, to where with the amendment at least still gives us that option if something else were to become more viable, more attractive to the entire township altogether. But at the same time, if Plan C fizzles out, we still have something that we voted on that we will meet the deadline of October 15th that says, okay, everything else, you know, Plan C and the mysterious other, you know, B, C, D, E, F, G never happens, then we still have A, we're going to meet that deadline, and we can go forward with that.
So, to paraphrase, what you're saying is to vote in favor of the amended housing element and fair share plan, at least put C out there as the potential, and if it doesn't happen,
We got A to fall back.
you have A to fall back on. Okay.
I'm not 100% against A,
Right, but-
because I
okay.
don't want the
But-
extra 300
right, but listen.
hours, but...
That's the easy one, because the straw poll was 5-4 anyway. The harder one is, if you're going to do that, can you guys please go around the horn and indicate whether you like the 6160 split or the 7150 split? Since you spoke first, why don't you go again?
I like the 50 split.
Better than the 6160?
Yeah.
Okay? Joe?
Slightly in that direction, slightly. I'm heavily in that direction, because it takes 50 homes off the books.
I agree, actually.
I'm also heading in that direction, as you know.
Yes, I'm in that direction as well.
Okay, so can someone make a motion to adopt the amended housing element and fair share plan, but subject to an amendment to have Beth amend it before it is sent back in its adopted form to change the split from 6160 to 7150? Can someone make that motion?
So, I'll make a motion.
He yelled it first.
C.1? Doesn't matter.
Okay.
That's good.
Yes, we will.
Okay, roll call.
Mr. Joseph Chichella? Mr. Bruce Williams?
Yes.
Ms. Kathy Cullen?
Yes.
Ms. Donna Marie Condos?
Yes.
Mr. Mark Scuderi?
Yes.
Mr. Gary Hill?
Yes.
Mr. Joseph Yama?
Yes.
Mr. Bill Cognac?
Yes.
Ms. Pam Palis?
You got it right, like the first
I
three
know.
times.
Sorry.
Okay.
But thank you for doing something.
All right, that's it, right?
That's it.
I have an motion to adjourn.
Adjourn.
Motion, second, all in favor? Aye.
Can we get that email?